And there's a judgment, I think.
For judgment, DB matter, item number 1.
Anybody appearing? You are there, right? And you are also there? Now what we have done is, admittedly, the petitioner was senior to respondent number 7, right? From the date of appointment. And their seniority position was also directed to be adjusted that way. Thereafter, there was a seniority list where she appeared as a senior to respondent number 7. Thereafter, 2008 CPT she passed and she was placed fit list, right? And thereafter, of course, there was some seniority list where she was adjust junior. That was, according to us, was not correct. So what we have done is we have directed, of course, promotion is again not a right. So what we have done is we have directed the concerned authority to consider her, to reconsider the seniority position, as well as to consider her promotion, even by promoting her to a supernumerary post. Okay, without, of course, entering into the promotion of respondent number 7 or all. We will not like to disturb her promotion. But by giving a supernumerary post, she can be considered for promotion, as we cannot direct. Okay? And this is so partly allowed. It will be out, and 1 or 2 mistakes, that will be out.
Made this Lordship. Lordship, I beg to mention here in item number 30. May I pray that this matter be listed after 2 weeks, Lordship.
30.
Lordship.
Okay, hearing. Criminal appeal. It's okay.
Yes,
Criminal appeal.
Lordship.
Do it. What happened to the is it a criminal appeal or what?
Correct, Lordship.
It's the nomenclature is little differently mentioned here. Why you
Lordship,
do
I am
it?
for criminal appeal 1 of 2018.
2018 matter.
Lordship.
What is there? You do it. It's only an
Lordship,
appeal.
today my senior have some other fixed matters, so he have some difficulties. So may I
It
pray
will
that
reach.
this matter be listed after 2 weeks. I've taken the consent of the other party also, Lordship.
The PP is there, right?
Yes.
And what about the informant? Is it a POXO matter?
Lordship.
POXO?
Yes, Lordship.
Oh, so the informant has to be there?
Lordship, but this is prior to that notification, Lordship.
Yes, prior to the notification, but then procedural thing can be applied even to the matters which were prior to the notification. It's better that we hear. You have not made a party.
Lordship. Yes.
So make her a party and issue the notice, right? Okay, take steps. In respect of item number 30, you write. Of course, I'll have to see can you give me the file once? Let me verify from the file. No, you have made her a party. This is in the main appeal, it is not shown, but then
Yes,
in the amended cause title is there, and then the guardian of the victim was made a party. So what about notice and all? Amended cause title file. Acha, notices have not gone. So write in item number, what? Item number what? 30, right? Mr. So-and-so appears for the appellant, as well as you are there for the PP. It is noticed that pursuant to the filing of the criminal appeal, the informant, that is the guardian of the victim, was impleaded as as respondent number 2, and the necessary amended cause title was also filed. As such, as mandated under the law, notice is issued to respondent number 2 the appellant will take steps for service of notice upon respondent number 2 through the office of the public prosecutor. List this matter after 2 weeks. In the meantime,
Right.
you take notice.
Lunch.
Steps to be taken within 2 days from today.
Please, Your Lordship.
1 second. Yes.
Lordship, I beg to mention admissions item number 25. Lordship, here I am for the respondent claimant. Kindly allow us some time to file our objection. This is an IA for restoration.
Oh, no, I for restoration.
Restoration.
It was dismissed for
MSc
default.
Yes, was
Restoration or condonation?
for restoration.
Yes, Mr. Longden. Item number 25. Acha, okay. 25. So, amended, what do you want? Against restoration or against condonation?
For the restoration, we are
Acha.
to file the objection.
Acha. You have to file objection. You want to file objection. Okay. Mr. So-and-so appears for the respondent.
Respondent claimant, yes.
Respondent claimant. And Ms. So-and-so, you are for the applicant. This I is filed for restoration
Restoration.
of the petition,
MSc.
with MSc appeal of the MSc appeal 2 of 2019. Mr. So-and-so appearing for respondent number 2, respondent. You are for all the 4 respondents.
For the respondent claimant only.
Respondents prays that he may be allowed some time to file the objection to the IA. Prayer is allowed. List the matter after 2 weeks.
Please, Your Lordship, may be pleased to mention item number 33.
33 hearing matter.
Yes, Your Lordship, our additional AG, Your Lordship, he is in bereavement.
Oh, yesterday someone told me.
yeah,
Who
that's-
expired?
Your Lordship, that I'm not aware, but he's,
Acha.
I'm just told that he's in bereavement. So, Your Lordship, after 3 weeks, Your Lordship.
They'll come out for 4 weeks.
Yesterday someone prayed for a month's time because of the bereavement. So, okay, Miss So-and-so appearing for the government and appearing for the
Praying
state
for
responsibility.
additional AG, yes, Your Lordship.
Praised that the additional AG who appears in the matter is in bereavement, and as such she has prayed for 3 weeks time to 3 weeks time, full stop. Mr. Longzam appears for the appellant. You are also there?
Respondent 3, 6, and 7.
Acha, and so for respondent number 3, 6 and 7. Prayer is allowed. List the matter after 3 weeks on a date to be fixed by the registry.
Much obliged.
May I please, Lordship? My Lord, I read to mention item 23 of
23.
Admission.
23.
Well, what happened is this R1 and 2, they are yet to file a field in opposition.
Oh,
I am for a petitioner. R3 to 8 they have filed.
acha.
And R2's affidavit will be relevant because it is the R2 who constitute ICC.
Acha.
Yes. So therefore, we given 3 weeks.
Someone appearing for R2.
Your Ladyship, I appear for R8. If I may just draw your Ladyship's attention to the last order dated 22nd May 2025.
Acha.
Your Ladyship,
In that case, shall I wait till the matter is called?
No.
Because I don't have to file now.
No problem.
we'll be grateful if
I
that
think
is done.
you can wait for some time.
Sure.
It will not take long.
No problem.
Okay.
Smart.
Let the matter be called.
Please, Your Ladyship.
Acha.
May I please, Your Lordship? Lordship, I beg to mention item number 3.
3.
Yes, Your Lordship.
Right? 3. It's a criminal petition.
Yes, Your Lordship. The conducting counsel, his mother is not feeling well, so she went to Gauhati for treatment. So, yeah. Can you please after?
It's a valid no? Okay. Miss So-and-so appearing for the petitioner
Yes, Your Lordship.
submits that the mother of the not required submits that the conducting counsel has some personal difficulty and as such has prayed for some time. The prayer is not objected to by the counsel appearing for the respondent by so-and-so, yeah, Moaz Amir. Yes. For the respondent, prayer is allowed. List this matter.
Fixed. Deal may be fixed in the bulletin.
Okay. Let
17 hours.
list the matter on
17.
17 is Sunday. 18th of August as agreed to by the parties.
Your Lordship, may I be allowed to mention item 32?
32.
In this matter also, the learned additional AG is appearing. This morning he had sought for some accommodation, but if this matter can also be discussed after 3 weeks.
Okay. There are only 4 hearing matters, 3 gone. And then in item 32 also, you write, the prayer is made by Mr. So-and-so that the additional AG is in bereavement, and as such, he has prayed for some accommodation. List the matter after 3 weeks.
Case and interim that may be continued.
Interim order passed earlier shall. Once what happened in a recent case, what had happened, I've seen in the records, that there were no interim prayer, but then perhaps somebody said, and then interim was continued, but otherwise there was no interim prayer. So let me see the file once. I have to be careful. Okay, just give me 32 item. I'm not, it's not that I'm not believing you, but for the sake of, so that had created problem. In fact, I ordered that it will maybe ignored. 32. Interim order is there. Interim order passed earlier shall continue. Don't mind, interim order passed earlier shall continue till the next date. But interim order earlier shall continue till the next date, of course, is there. But what happened? Okay. Take it. Okay.
No, Mr. Lordship, I'd like to mention item number 2, Your Lordship. Yes. You should hear the leading counsel has some difficulty today, Your Lordship. There's a part of matter in court number 1.
After finishing that, he can come. We can pass it over for the time being.
Might take the whole day, Your Lordship, the matter. Yes. However, Your Lordship, the counsel for respondent number 2, leading counsel for the respondent number 2 is also not present today, Your Lordship.
Respondent number 2 is also not there. Okay. Mr. So-and-so appearing for the petitioner. Prays for some accommodation, which is not objected to by the counsel appearing for the respondent. List the matter after 2 weeks on a date to be fixed by the registry.
Lordship, there's an interim, Lordship.
Interim order, I'll have to see or what? Interim order passed earlier shall continue till the next returnable date. Item number 2. Just to be little extra careful.
Lordship.
Just see. Okay.
Much obliged.
May I please, Your Lordship, may I be pleased to mention item number 5 to 22. Your
The
Lordship,
entire series.
Your Lordship, here I'm assisting my additional AG Vishakre, Your Lordship. However, she will be having her feet in the first court the whole day, Your Lordship. We are having a hearing. It is continuing from yesterday.
Oh,
so today it might be.
Therefore, there was another prayer also.
Yes, so Lordship, if it can come up on Thursday.
This Thursday, no,
Thursday,
this
Your
Thursday.
Lordship. Now,
Because Friday I'll be leaving, Thursday I'll not take up long matters. What is this matter
this
about?
is a short. 220, item number 5, Your Lordship, is filed only this year. Otherwise, item number 6 to 22 is pending since 2023, Your Lordship. 45, writ petition 45 will be the lead case. And here, Your Lordship, the matter relates to skill pay, which is covered, which is already covered case. Your Lordship.
Yesterday, one counsel showed me one notification where, I think of March 2025, where it is decided to regularize.
No.
No, Your Lordship, here is a slight difference.
No,
Oh,
these are these are petitioners are teachers who are appointed under SSA and Central Semester Scheme, Your Lordship. But so far as skill pay is concerned, it's already covered. Additionally, the petitioners are also praying for mainstreaming their service in the state education sector because they are appointed under SSA RMSA, which is a Central Semester Scheme, Your Lordship. So, actually, Your Lordship, this is a short matter, Your Lordship.
It can be disposed of.
Lordship, maximum I'll take 1.5 hour, maximum. So if Thursday, if it can be listed for admission hearing, Your Lordship. You can
Okay, we will try. If
Lordship.
it prolongs, then I
Lordship.
might not take up. Okay, item number 5 to 22, you write
5 to 22.
that Ms. So-and-so appearing for the state respondents submits that there is some personal difficulty in conducting the case today, and as such she has prayed the matter to be taken up on Thursday next. Mr. So-and-so appearing for the petitioner
Petitioner.
also agrees to the same.
And even for the union.
Acha. List the matter on when? Date 24th.
24.
24th of July.
Population. Okay.
Much obliged. At least, Your Lordship, I'd like to mention item number 31. Hearing item number
31. Oh,
Yes.
all hearing matters gone. Why?
What the on the consensus of both the parties, if the matter can be listed after a week.
Why? What is the reason?
The
You can do
counsel
it.
for-
2019 matter.
Yes, Lordship. The counsel for both the parties, they are engaged in a part heard matter in court number 1 today. So there is difficulty.
What
to
is
take up
that
the
matter in court number 1? All are engaged. Do it. You can do it.
The counsels have expressed their difficulty to take up the matter today, the leading counsel.
Okay. In item number 32, you write so and so prays that that there is some difficulty in respect of the conducting counsel to do the case today. You are for the
Petitioner, Lordship.
Miss so and so appearing for the petitioner also, which is not objected to by Miss so and so appearing for the petitioner. List the matter after a week on a date to be fixed by the registry.
Much obliged. Item number 31, Lordship.
31. Yes.
Obliged.
31.
For motion from the supplementary cost list, item number 34.
Yes, Mr. Zamir. What is this matter about? Moava Village Council.
Your Ladyship,
Yes.
I'm aggrieved by an order passed on 20 June 2025. Passing an application is for continuation of delay of 819 days. That was filed accompanying where an appeal was also filed. So, to prefer an appeal before the Deputy Commissioner, as provided in the Rules of Administration of Justice 1937, an appeal was filed, but there was a delay of 819 days. On hearing the application was rejected.
Achha.
So, being aggrieved before this honorable court.
Today, then let the notice go then.
Yes, at this stage.
Miss, this is an application under Article 227 of the Constitution of India, read with Section 151 and 115 of the CPC 1908, challenging the judgment and order dated 26/2025, passed by the Additional Deputy Commissioner. The appeal lies here
Yes.
to the High Court
Yes.
under the Administrative
Yes.
Justice, by which, passed by so and so
Chumukidima.
in Chomokedima, Nagaland, in connection with IA number 1 of 2024, by which the learned Additional Deputy Commissioner refused to condone the delay of, where is the impugned order?
Page number 36.
It's a very short order.
36.
No. Delay, refused to delay, condone the delay of 973 days.
819 days.
Here it's written 973 days in the impugned order.
Fifth line of the order, if your ladyship may kindly.
What about, no, page number 39, you see the operative portion?
Yes.
970.
Wrongly reflected.
Is it?
Yes. Yes.
900,
Otherwise, if your ladyship may kindly.
528. It's at some, in some places it's written.
I have enclosed the IA.
But see, so many different days.
Yes.
In the
that is
first paragraph, you say 819 days. Then comes to 528 days.
So many errors committed by the.
Yeah. Anyway, I'll put that whatever is there in
I
the
haven't closed the
operative.
IA, I have mentioned 819 days in the IA, page number 28.
Okay, 973 days, right? Then after, the counsel appearing for the petitioner, however, says that the actual delay was how much?
819.
819 days. Issue notice, that you clarify during the issue notice to the respondents,
There are two
1 and 2.
respondents.
The petitioner, the petitioner will take steps upon service of notice, for service of notice upon respondent number 1 and 2 by registered post with AD, as well as by usual process. List this matter after 2 weeks.
For admission, item number 1.
Admission. Sorry. This is contempt petition.
Yes, my ladyship.
Yes.
This is a contempt petition filed for non-compliance of this court's honorable court's order dated 10/11/2022, passed in WBC 250K of 2022.
I think the wakalatnama on behalf of respondent number 2 is not filed.
So the respondent number 2 is being represented by,
You are there.
yes.
You have not filed wakalatnama, it seems. It's shown in the office note. So, okay, because let him file the wakalatnama.
My ladyship, just to clarify something, as per the last order,
Ah.
the learned counsel for the respondent number 1 and 3 was directed to obtain instruction as to whether the case of the petitioner has been taken up for consideration. It was taken up before the district level verification committee for consideration of his case for regularization, because as per the OM of 2015, those cases whose case cannot be taken up on the as per the notification OM, there has to be taken up in 2 pages. That is 1st of July and then 1st of this January every year. Now the order was passed on 10/11/2022. Since 12 December was approaching, this honorable court has directed to
From 22, the things are not
yes.
complied with. Where is the impugn order?
Impugn order is at page number.
Oh, I mean, where the directions?
The direction, the page 25.
Some of them have filed their objections and all, right?
Not objection, but just counter affidavit stating that my case could not be considered because of the non-constitution of the district level variation for not forwarding my case to the DLDC.
Acha, acha. And where is the directions? Which page you said?
Page number 25.
25.
And the operative portion is at page number 28, last page. It's only a 3-page order. Since the convention.
Oh, 17.3, to whom I know. 17.3 is that whoever enjoys scale pay and then
Has completed
we're continuing for 30 years
Yes.
will be regular,
Yes.
will be regularized.
Regularized. Now I have already completed 30 years, and then before my retirement I have applied for regularization, but that was not considered, and then I was retired without regularization. That's how I approached this honorable court for regularization in terms of.
So you retired on receiving fixed pay only,
No,
entire?
on scale
pay.
pay,
Okay,
yes.
on scale pay.
Yes.
And then you had completed 30 years also. You were
Yes.
covered by the OM.
Yes, that's why this honorable court has directed the authorities to consider my case, to regularize my case, not to consider.
Even day before the retirement.
Yes, they could have, but it was not done. So I have approached this honorable court.
Why it is taking so long?
Yes, that is the only thing.
And time limit is given.
No time limit, but my ladyship, the last page 28 may be allowed to read till
Yes,
last.
yes,
Since the contentions raised by the petitioner
I've gone through.
yes. So because this order was passed in the month of November, and since December was approaching, as per the OM, it was to be taken up in the 1st of January the next year.
Huh.
But it was not considered. Thereafter July came, it was not considered again. December came, it was not
Yeah,
considered.
it's too long. Why it is
That's why
taking?
this contempt was filed.
Yes.
Your ladyship, in the order list, no time frame was.
No time frame, but then see, she has retired.
No.
She is without any pensionary benefits.
Yes.
The problem with the state, your ladyship, there are two respondents in the contempt. Director Higher Education and the principal Fazal Ali College were the contempt respondents. Now, when the process was initiated, the respondent number 1 retired out, that is the director, and the second incumbent came. That is on the last occasion only, the incumbent director was embedded as a party respondent because the first party, the first director was already retired out. Now, whatever the case, now we are taking the initiative. But my letter tweet is saying about 17 March 2015 OM. Now in the OM, of course I did not dispute. One page has to be sent in January, one page has to be sent in July for regularization. But there are certain things to be done. The particular person who has to be regularized must have to be verified. His antecedents must be verified by the district level verification committee. That is, the committee deputy commissioner is ex officio chairman. So unless the person is verified by the district verification board, then it is not possible. Now,
But then it will not take so long.
Yes. And then who will place that?
22.
that is why, unfortunately, the name of the petitioner could not be verified by the district level verification board. Accordingly, it is taking time. It is taking time. It is taking time. That is why it is not that person has to be regularized like that way, in a very simple way.
Of course, some exercise has to
What
be.
we do in Nagaland, what we do in Nagaland for regularization process is that person serving in a particular district must be verified by the district level verification board. And after that, it has to come to the department concerned. And from the department concerned, directorate concerned, it has to go to the government. And from the government, it has to go to the BNR. And drafted to the finance, and drafted to the state cabinet. So the procedure itself is lengthy. And
State
number
cabinet
one,
is not required. Why cabinet?
no, that is the procedure that we do.
OM is already issued. Now
OM
that
was
has to
already
be
issued,
followed.
but that is the practice here. That is the practice here. Lordship your ladyship will know. That is the practice here. So now, in the cabinet, even at the cabinet also, if it is not that important subject, then it is not been taken out, as your ladyship is well aware. So the process is very lengthy. It takes years and years. And we collect all the work charge, casual, contingency, not in a single individual, but in a crop basis. And it is accordingly sent to the BNR, finance, cabinet like that. So that is the thing. But in the case at hand, very unfortunate, the petitioner could not be, his name could not be verified by the district level verification board. That is why it is taking time.
But see,
but your lordship, I assure you, will definitely do. Will definitely
But
do.
you don't mix it up with other cases
Yes.
because there is a court order here.
Yes, my ladyship.
So this has to be given preference and has to be taken up.
It has to be taken up with all seriousness because an order from this honorable court is there. That I have all the due respect for the pronouncement of this court.
So what I will pass is that on the next day,
But one issue here is no time frame was given
No, my
by this
even then,
court.
of course, no time frame. But then things has to, there is a court order, you do it reasonably, within a reasonable time. Not like 3-4 years.
Yes.
So what I'll do is, I'll pass an order, the next day you file an affidavit showing the compliance. Have you already filed an affidavit showing the steps taken?
No, just that the affidavit they have already filed, but no mention about the steps.
No mention about the steps.
Just they said like my name was not, my case was not considered because it was not verified by the DLBC, and then they have made some apology statements stating that it was not intentionally only that. they have to mention what steps they have taken up.
So on the next date, you mentioned the steps that has been taken by the government towards regularity of following this order. And that is what, then after that, because although no time frame, it has to be done within a reasonable time period.
Yes.
Right. So, okay, I'll dictate.
My ladyship, though no specific period has been mentioned, but the order is very clear. It says as per the OM, which means that it has to be considered in the month, either in the month of December or 1st of July, because the order was passed in the month of November, and then as per the OM, it has to be the 1st of January.
Where have you said it is in the month of November? What is that?
My lord, my ladyship, the OM is at page number 14, annexure A.
14.
Yes.
Yes. Okay.
This is the OM for scheme for regularization and absorption of workers and casual employees in division of pay in wages. Here, and then the operative part is at page number 15.
Clause 2.
2.
In respect of those work charge and casual in scale pay and who have completed or will complete 30 years of service after 1/1/2015. Okay. And their cases of regularization will be taken up subsequently in 2 batches, 1st July and 1st January. Okay.
The procedures and terms of reference will be the same as this. So as per this OM, my case is to be considered.
No, as far as this OM, okay, this July and January is there. But in respect of those employees, but where there is a court order,
Yes.
that July, January may not be
My
requirement.
This honorable court has directed to consider as per the OM. To regularize my service as per the OM. So as per the OM, my case has to be taken up for regularization. It has to be placed before the DMDC or whatever it is. It has to be in the month, in the 1st of December, January, and if not, then July. Now that 2 years has already lapsed. January, the 23.
So this December, they can, this January.
January is also gone again. Now July, this is July again. So whether the 1st of July has already lapsed. Today is
July, number of days have gone by already.
Yes.
So what I'll say is, within this month, the government has to consider regularization as per the OM.
I've already explained.
Those processes, those steps.
Difficulty of the government. Please appreciate the difficulty of the government. Your ladyship may kindly see my affidavit. Your ladyship will find my affidavit on behalf of respondent number 1 and 2.
Yes, yes, affidavit, no, this is service of notice then. And, yes. Respondent number 1 is there.
Yes.
1 and 2 together?
No. He is the principal. He is only a performer respondent.
Okay. This is one affidavit dated 15/1/24.
Yes.
This is by respondent number 1 only. Then, yes.
Your ladyship may kindly see para 3.
Para 3 will be relevant.
That in compliance.
May I read your ladyship? That in compliance of this Honorable High Court order dated 10/11/2022 passed in WBC so. And in consonance with the OM dated 17/3/2015, the OM is what my learned friend was talking about. Scheme for regularization of workers and casual employees. The answering deponent has taken initiatives for regularization of the petitioner by following the procedure in the OM. However, the problem is this one, your ladyship, kindly appreciate this. However, it was found that the petitioner was not verified by the district level verification committee as per para 1 Roman 1A of the OM dated 17/03/2015. And as such, the regularization of the petitioner could not be processed.
Why was his case not verified? It was because of his mistake or what?
No, it has to be placed by the authorities.
That is the problem.
Huh.
One has to be verified.
Huh.
A work charge has to be verified
Huh.
by the district level verification committee. So it is very unfortunate that the petitioner could not be verified.
Why?
He
What?
might not have attended the verification when it was false.
So I'm asking whether because of his fault it was not done. Otherwise,
No,
why I'm serious with the matter?
I don't blame anybody, but why he should not be there for in the verification, district level verification board? That is my only question. I don't have answer to that.
Acha, whatever it is, now that 22 what month the judgment was passed?
11 November.
November.
Yes.
Okay. 23, 24, 2 years have gone. And see, he is without any pension benefits. Right. So we have to follow Supreme Court judgments. So many.
Your ladyship will, the one problem, please appreciate the problem of the state also. One problem is that he is out of the service. Petitioner is not in active service, he is out of the service.
No, he is retired.
That is not
So
right.
we need to,
But then we have to come down heavily on the
I appreciate
for
the
non-compliance
findings
of court's order. Otherwise, what is the purpose of court's order?
I appreciate the findings of your ladyship, but please appreciate the difficulty of the government also. Because
Okay.
otherwise,
What I'll do is you file an affidavit and taking what steps were taken till date, and there are still many more days to go in this month of July. So in this month only, what I'll say is his case has to be considered. Okay. Okay, Mr. So-and-so appearing for the petitioner, and Mr. You are additional AG or what?
Moa engineer.
Yes.
Moa engineer.
Moa Imchen. You are for respondent
1 in 3.
1 and 2.
3.
3. 2 is yet to file. 1 and 3 are who? The Commissioner Secretary.
To the director.
Acha, Director Higher Education, and 3 is implemented later on.
Yes, later on.
He is also Director.
Director, because the earlier director, she was transferred out, and then the new incoming.
And you are for principal of the college where he worked. Okay. Mr. So-and-so, Moa Imchen appears for respondent number 1 and 3. And Mr. Ameju Momi appears for respondent number 2. This contempt application is filed for non-compliance of the order dated, of the judgment and order dated
10, 11, 22.
22 something, what, where is the, what page, 25 you said, right?
10, 11, 2025.
10, 11, 2025, by which this court had directed the authority concerned to regularize the services of the petitioner in terms of the OM dated 17/3/2015, issued by the PNR department by following the procedure and time schedule prescribed in the OM. The petitioner submits that till date his case is not considered and the directions were not followed. And as such, he is constrained to file the contempt petition. An affidavit in opposition was filed by respondent number 1, no? Only one. Okay, one only that time. Respondent number 1, stating inter alia that the petitioner, stating inter alia that in consonance with the OM dated 17/3/2015, the respondent had taken steps for regularization of the petitioner. However, it is stated that the petitioner was not verified by the district level verification committee as per the said OM. And as such, the regularization of the petitioner could not be processed to the Department of Personal and Administrative Reforms for approval by the government. He also states that for regularization, there are many steps to be gone by, and the said steps have consumed the time that has gone by. In the OM dated 17/3/2015, 17/3/2015, it is stipulated in Roman 2 of clause 1 that the work charge and casual employees who are in scale pay and who have completed 30 years of continuous service, their cases must be taken up in 2 batches. Their cases for regularization. Their cases for regularization was directed to be taken up in 2 batches as on 1st July and 1st January every year.
Your Ladyship, kindly see this page 14, that OM, number 1, bracket A.
Yes. Incumbent concern and his service rendered have been duly verified. Okay. And found genuine.
After this, the petitioner has to cross this hurdle.
Yes. In the said
Only the particular employee can be said.
in the said memorandum, it is in no unclear terms provided that the work charge or casual employees who are enjoying scale pay and who have completed 30 years or more of continuous service will be regularized by converting their post into regular ones. However, the same was subject to certain conditions, such as the service rendered by the said employee should be properly verified, and only when it is found genuine by the district level verification committee, the regularization can be given effect to. However, although the said condition is provided for before according regularization, however, the directions to regularize the petitioner was given more than 2 years back. And it is desirable in the consideration of this court that the said exercise should not take such a long period, and that the directions of the court should be complied with all seriousness and within a reasonable period of time. As such, this court directs the respondent number 1 and 3 to file an affidavit showing the compliance of the court's order, and also to reflect the steps taken by the government or the authority concerned as per the notification, as per the memo dated 17/3/2015. Full stop. It is also directed that the concerned authorities may consider the regularization of the petitioner within this month in view of clause 2 of the said OM dated 17th March 2015.
Your ladyship, allow some time, please, because
Consider only, I have said consider, you file the affidavit and to consider also. And, okay, full stop. The affidavit may be filed by 28th of July 2025, that is on Monday. Matter to be listed on 29th of July 2025. Okay, you show the steps then that this court will consider. Okay? Yes.
For admission, item number 4.
Criminal petition. No one is there? Mr. G. Deka, perhaps from Gauhati. None represents. The petitioner on call. On the last occasion also none appeared for the petitioner. Where is PP? Just now he was there. Oh yeah, you are there. See, last time also nobody appeared.
Your Ladyship, I'm not in this case, so I'll
Acha.
try to find out.
Wakalatnama filed on behalf of respondent number 2. This is a criminal petition under inherent power perhaps. So it can be dismissed for default also.
Yes, yes, yes.
There is no bar.
Yes.
Acha. No, last time also nobody appeared. This is for quashing of the FIR
Lordship.
and 41A notice.
Lordship. On 2-3 occasions, Lordship.
It seems one occasion on 24. Oh, acha, wait. Oh, Mr. Sahewala appeared for the petitioner on, well, that was long back, April 2024. Then after that, from September 2024, oh no, after that there was representation. None appears. G. Deka. Okay, from I think March 25. No, in between again somebody appeared. So, okay, none appears for on call. It appears from the last order that the counsel did not appear on that occasion too, and on many occasions the counsel for the petitioner had not appeared, as is reflected from the order sheets. Learned PP V. Jemomi is present. List the matter after 2 weeks. And if no one appears on that occasion too, steps can be, necessary orders can be passed. Then it will go as a signal to the council.
For admission, item number 23.
20? 23. 23 days an adjournment made? Oh yes. Yes. You are there.
Your Ladyship, I appear for respondents number 5 to 8.
5 to 8.
Please, Your Ladyship. Your Ladyship, may I just draw your Ladyship's attention to the last order,
Yes.
which is order dated 22nd May 2025, whereby they had sought time to file my replies on record, and their rejoinder was to come on record.
Yes, are not necessary parties. 5, 6 and 7 are not necessary parties.
That was my submission even last time. Your Ladyship, if I may just take 2 minutes of the court's time. This is a writ petition filed by an IS officer who at the time of the offense was serving as Joint Secretary of IDAM, the Investment Development Authority, Nagaland. About 10 women who were working there, who are contractual employees, complained of sexual harassment.
Acha.
The matter was taken up by the Nagaland State Commission for Women, which is respondent number 8, before your ladyship.
Yes.
On the basis of the verbal complaint by the chairman of IDAM, and after hearing the women, the Nagaland State Commission sent a complaint to the police station, SCPS. Thereafter, after conducting a preliminary inquiry under 173(3) of BNSS, where due care was taken that, is there prima facie is a case made out, an FIR was registered. The FIR is dated 2nd of...
Then?
Your ladyship, presently, the charge sheet stands filed. This petition filed by the petitioner is seeking a quashing of the FIR, and obviously the charge sheet has been filed only recently.
Otherwise, it's registered as repetition criminal. You have approached under 227 or what?
I represent the Women's Commission and the
No, the petitioner, yes. Now this is under what?
Just one more aspect why I had even last time submitted. The members of the individual members of the Women's Commission, including the chairperson, have been arrayed as parties 5 to 7. Actually, the whole process is meant to intimidate anybody who is taking up the issue and placing it before the relevant authorities. This same petitioner is facing prosecution under POCSO, under section 10 and 12 of aggravated sexual assault of 2 minor girls who are poor minor girls working as domestic help in his house. He was never suspended. That case is ongoing as prosecution evidence, and then this has happened. And now this
He's
petition...
still working. He's still working.
He's now under suspension. The suspension was only now after this case was registered.
Okay. But what to do today? What is the stage? Like, what?
If they want to drag it, they can, but they have made a range of pro forma parties. Your ladyship may have a look at the array of parties. It is their petition for quashing. As long as it does not come in the way of proceeding with the trial, the charge sheet has been filed. They want to say it, I would not say anything to that. But to say R1, which is a government, the state 3 and 4 have filed, 5 to 8 have filed. The others are former party. If they wish to argue, we are ready. If they don't wish to argue, that is between them and the court.
So, affidavit in reply was supposed to be filed by?
Petitioner.
Petitioner. That has not been filed. No. 2D, affidavit in opposition filed by?
3 to 8.
3 to 8.
1 and 2 yet to file.
Their objection.
Yes, because my lord, your leadership.
Your ladyship, I have filed affidavit on behalf of 3 and 4, and that will cover the respondent which I'm representing, 1 to 4. So there is no point of filing another affidavit. That will suffice.
My humble submission.
Only he has to file his reply.
Yes.
But what reply in criminal petition?
One humble submission.
Your ladyship.
It's okay.
Yes.
No, it's okay. Yes, one of you proceed.
Okay. No, I give chance to.
No, nowadays there is no proportion of ladies first. That is gone. Those are of gone days. And then
we are confident of standing on our feet.
Yes, no, not required. Yes.
Your ladyship.
No, this is a criminal petition for quashing of FIR.
Correct.
What is the purpose of objection, reply, and all those?
No, there are certain facts that I need to file.
Achha.
The new facts are there. Initially, your ladyship will appreciate. At the time of filing FIR, the information by the chairman, Nagaland State Women Commission, the statements of the alleged victim were never part of the record. Now it has come. At the time of filing the complaint in the name of the chairperson, Nagaland State Women, it was just complaint in the name of statutory body. Now, there at the time of filing FIR, no information has been enclosed. They say that
it's okay, it may not be an encyclopedia, it's only first information.
Now it has come. They have filed in the form of affidavit now. So it has come to light. So therefore, I want to clarify certain allegations, that much. So I won't take much time. I may be given just, I was away for 2 weeks for my wife's checkup. For 2 weeks. So I was out of station. Only today, yesterday.
Okay.
So
Your
therefore,
Ladyship, as far as our affidavit is concerned, we have filed on the maintainability of this petition.
then I'll reply to that.
Nothing
no
more than
problem.
that. And Your Ladyship,
Sustainability, why? He can always come for crossing of FIR.
Yes.
Your Ladyship,
no
it may
merit.
be a legal argument
On
that will
merit,
have to be addressed,
No problem.
because we will,
I'll reply, no problem.
yes.
So
Your
therefore,
Ladyship, in fact, the matter has become infractious also because the investigation has already culminated into a charge sheet. Now
Yes.
the petitioner may pursue appropriate remedy before the appropriate forum.
You have not prayed for
And
quashing
no,
of the
o-
subsequent proceedings.
only now I'm
No,
coming
no.
to know that they have come for charge sheet. Only now I'm coming to know.
This
Then
morning, in
you
fact,
want, you do one thing, you withdraw this, file an amended criminal petition. That is for no one, for me
Your
not to
Ladyship,
advise,
they
but
kindly
then.
peruse the charge sheet also.
Also we'll see.
They have handed over to me this morning inside the courtroom.
Acha, charge sheet,
Yes,
it's
char-
okay. You
yes.
can charge sheet, charging them.
Yes, it has. That's what I have been informed.
Ah.
So the legal
The
position
only-
has already changed.
No, the only
And
thing
in
will
fact,
be
the
as-
It's okay, it happens.
Even if, let us assume that
Yes.
Iowa has filed charge sheet. Still, unless the court take cognizance, I don't know whether that is done or not.
Those
so I
steps
don't
will be
know.
taken.
Yes.
But the fact
before the
remains,
concerned
you
court.
have,
I my limited prayer today is, since I deserve,
yes,
at least
sometime.
I deserve something to reply. Factually, new facts have come before the court on record. So that I just want to refute all those allegations that much. So
okay,
therefore,
but he has,
Your Lordship may pass necessary order in IA because this is for the stay of the investigation. Now it
I'm
has
not-
been
there's no
charged
stay,
that there is
no
no.
stay.
There is
Yes,
no
so
stay.
so this may be deleted.
trial will proceed, there is no stay at all, the trial will proceed.
So the prayer cannot sustain now. The prayer for stay of investigation, it has already been culminated.
oh, stay of
Yes.
investigation, now the charge sheet is
Yeah, it
submitted.
becomes infractions.
I'm not insisting on that also. So I may be giving 2 weeks time so that I'll reply to those allegations.
I'll close it
Yeah.
because there's no
No
purpose.
issue that, no issue on that.
Okay, and where is that IA? Right in the IA, the Miss so-and-so, the learned PP for the state of Nagaland submits that the pursuant to the registration of the case number State Crime Police Station case number 1 of 2025, the investigation was conducted. State Crime Police Station case number 1 of 2025, huh?
Yes.
The police had investigated and had submitted the charge sheet on
They have submitted on 30th of June.
Right down.
30th of June.
submitted the charge sheet on 30th of June 2025.
It's addressed to the Chief Judicial Magistrate dated 2nd of July 2025.
You don't have the charge sheet with you?
Charge it is here. If your
What is the
your
date? Date
ladyship
is 7th. The date is June. Yeah, charge sheet dated 30th of June 2025. White charge sheet number 6 of 2025. It is submitted at the bar. It is submitted by her that since the IA is filed for stay of the investigation carried on in pursuance to the said FIR. No, this is for impleadment of somebody. Where is that IA? There are more files. There is the list. This is item 23. There is no, IA criminal 6 of 25.
Yes.
There is the 6 of 25, but this is for impleadment. Right. Application for impleadment 6 of 25. There is no
If
IA
that's
for.
the case, yes.
Okay.
No.
There is no.
It can be made, yes.
Maybe it is made in the.
In the main petition.
Main petition
Yes,
only.
yes, in the main petition, yes. The interim prayer was made, yes. Yeah.
There is an interim prayer, Your Ladyship, at page 18 of the writ petition.
Yes. And as such, she prays that the interim prayer made for stay of the investigation has become infructuous. Mr. So-and-so appearing for, yes, Mr.
Adjournment.
Azo. Mr. Azo appearing for the petitioner, however, has prayed for some time to file his affidavit in reply to the main writ petition criminal number 10 of 2025. The prayer is allowed. List the matter after 2 weeks.
Yes.
Your Ladyship, may I just interject?
Miss so-and-so appears for respondent number 345 or what?
No, Your Ladyship, 5 to 8.
5 to 8.
Your Ladyship, may I also request a preliminary issue that will need to be decided? Is the arraying of 5 to 7 as who are members individually as party, and thereafter this court therefore directed that respondent number 8, the commission should be made a party. This is the way they're trying to browbeat by making the members individually. These are all tactics. We are all familiar with them. He's an IS officer. He knows how to play the game. But this is not, the court will have to therefore stop it.
We are there. He cannot play a game.
Let the preliminary issue be decided whether 5 to 7 are at all necessary parties.
No, it has already been reflected in the last order, as you have said. She also said, but let you be there. Let the matter be heard and finally decided. On the next date, it can be done.
Please, Your Ladyship.
Oh, yeah, I can also do it today also if you are ready.
Yes.
I must file a short reply.
Because criminal petition, what reply?
No, I need some facts. You have to reply. Ultimately, the criminal case is pending. I just want to file some reply.
Okay, on the next date it will be done. Let you be there.
It will be done.
Please, Your Ladyship.
Fight against him. It's okay.
Yes. Please, Your Ladyship.
List this matter after 2 weeks.
Much obliged.
Okay.
I'm grateful.
Miss So-and-so appears for 5 to 8.
For admission, item number 24.
Please, Your Ladyship.
This is to her. Yes, yes. This is again petition.
2 and 3.
I remember seeing these names. No. Oh yes, that is what my order is there. It is for quashing of FIR.
FIR in charge sheet.
Okay.
Please, Your Ladyship.
Yes, 1 second. I'll just go through the last order. What had happened? Oh, this is a joint petition. I have told him to file an affidavit.
Yes, Your
Okay.
Ladyship.
Yeah, have you filed it?
Yes, I filed.
It's on records.
Yes.
On behalf of respondent number 3.
2 and 3. 2 and 3.
2 and 3, but it's written 3. It's okay. Affidavit filed by respondent number 3.
Yes, yes.
And who is respondent number 3? The victim.
The victim.
What was this matter about? What offense? 140. What is 140 of BNS?
140 subsection 2.
What is that?
Kidnapping for ransom.
Huh?
Kidnapping for ransom.
Oh, kidnapping for ransom.
That case. Last week we have heard twice in this matter.
Yes. He was picked up because of some money
Financial,
transactions.
yes.
Okay.
Between petition number 3 and the alleged victim, respondent number 3.
And what about respondent number 2? Who is he?
He's a complainant. He's the council chairman.
Oh yes, he is the council chairman, not a necessary party. Well, let me go through his affidavit.
Yes.
Because the language that you write is he was picked up. No.
Yes, Your Lordship.
He respondent number 3 is picked up by the persons. You have yourself written that sentence at page number 2. Thereafter, petitioner number 3 sends his friends to his home on 12/8 and he was picked up and was taken to his place. Subsequently, answering respondent and petitioner number 3 had a discussion wherein answering respondent had agreed to give back the aforesaid amount, but he was not in a position to repay back the aforesaid amount at that relevant period of time. Thereafter, respondent number 3 called up the parents. Petitioner number 3 called up the parents of the answering respondent and told them to arrange the money the next day. Answering respondent's parents were not aware of the financial dispute that was pending before them, and so the parents went to so and so. Respondent number 2 respectfully submits. Respondent number 2. This is an affidavit by respondent number 3,
Yes,
and then you say, okay, respondent number 2 respectfully submits. On the next day all the 3 petitioners were approached by police, and after their arrest, you should have written respondent number 3, I think.
Yes, Your Lordship.
The respondent number 3 is on the next day, all the 3 petitioners were apprehended by the police, and after the arrest being made, family members came to the respondents of council chairman for discussion of this case, wherein answer respondent was also present. After thorough discussion on the matter, answer and council decided to forgive the acts committed by petitioners on a compromise date. Suddenly, that since the petitioners and the answering respondent have come to a mutual settlement. Okay, so Miss PP, he has also agreed. Picked up, parents did not know. They went to the council. FIR was filed. Now that they have entered. Now that both the parties have entered into an agreement, I don't think so there will be any purpose for trial.
Your Ladyship, the remoteness that Your Ladyship, he has agreed to Your Lordship, but then here the offence is serious, and then I'm emphasizing on the non-compoundable offence.
Huh?
So if I may, it is a non-compoundable offence.
No, it is a non-compoundable.
The agreement entered into, that is a private settlement, and the action, the offence, it affects, it has the bearing, it has an impact on the society. So on that, I may be allowed to raise two rulings. One is
Every offence is offence against the state and against the society. That is an admitted fact. But whether there will be any purpose for holding the trial after they have entered.
the kind who, the Lordship here, in the case of the state of Madhya Pradesh versus Lakshmi Narayan on March.
Yes, this is in tune with Gyan Singh and all those.
Yes, that has been there. Yes.
Parbat Bhai.
Yes.
And those are there unless matrimonial issues, financial, commercial transactions.
Yes.
In those cases, okay, but not in serious offences. This is what is stated. Right.
Emphasis is on non-compoundable.
Non-compoundable, that is why they are before High Court. And what about the other case?
Yes. Para 4, 5, 6, 7 and 8. In the other case.
Simple in nature or are heinous?
It's serious.
But this is butt of the pistol in the facts
Here
of
in
this
the-
case.
Yes.
Thereof
In our
video
case,
was prepared.
He has been blindfolded. The accused has been, the victim has been blindfolded and he has been taken to unknown place. So all these are the ingredients meet the
Okay, I'll take into consideration these cases, but there is there in Lakshmi's case that if there are no chances of a trial, where is that portion? Where is that paragraph? Perhaps it's there in the Parbat Narinder Singh also.
Yes, Gain Singh's case is in para 9.2.
9.2.
Yes.
29.2. What? No.
There are 2-3 paragraph which I have highlighted. Oh, para 9. In
Para
short, para
9.
9, yes. Oh, no. That is the observation of the High Court.
Okay, I'll go to it. Okay, then, right, Mr.
Vinokacham. Vinokacham.
Your name is there, right?
Yes, petition.
Searching for the petitioner, heard Mr. So-and-so for respondent number 3, and you have respondent number 1, right?
Yes.
So respondent number 1. This is an application filed under 528, right? This is an application filed under section 528 of the BNSS 2023 for quashing of the FIR number 24 of 2024 dated 13/8/2024, as well as the charge sheet number 11 of 24 dated 27/8/2024, as well as the further proceedings in the instant case. Further proceedings instituted in the present case. Where I have written FIR dated so and so, registered under section 140 subsection 2/3 subsection 5 of the BNS, as well as the charge sheet and the subsequent proceedings. The petitioner had prayed, in the present petition, the petitioner has prayed for quashing of the said FIR as well as the charge sheet on the ground that settlement was reached. You all can sit, no need to stand up, sit. Settlement has been reached between the parties, that is between the petitioners and the victim. The victim. Wait. Before that, you write the FIR dated no, not before that. You write after that only. Okay, it was settlement between so and so. The FIR dated 12/8/2024 reveals that the petitioners not petitioners, and at that time those were unknown miscreants, right? FIR reveals that the victim, namely Mr. Salman, who is respondent number 3 herein, was kidnapped by 4 unknown miscreants from his home on 12th of August 2024 at around 4 to 5 p.m. It was also stated in the FIR that the miscreants had demanded rupees 2 lakhs to be delivered at Vihokhu Village Junction, VIHOKHU, Vihokhu Village Junction at 8 a.m. on the next day of the said kidnapping. The FIR was lodged by the chairman of the Lotovi Village Council, who is arrayed as respondent number 2 in the present petition. In pursuance to the said FIR, the police registered the case under the aforesaid sections. And commenced the investigation. However, on 24th of August 2024, where is any forwarding report where the charge sheet is not submitted? Oh, charge sheet is submitted? Yes. Commenced with the investigation. Thereafter, the charge sheet was submitted by the police.
Page 25.
On
27/8/2024. Page 25.
25. Yes. Charge sheet was submitted on 27/8/2024. it is stated that during the investigation, the police identified the accused persons, and all the 3 accused persons, they were arrested.
Yes.
Yeah, they were arrested by the police. There are statements of the witnesses in the charge sheet. It is written in the charge sheet that on the next day of lodging of the FIR, that is on 13/8/2024, on the information given by the father of the victim, father of the victim. What is SOT? Special something. See at page number 30. Perhaps police personnel, right?
Yes, a special operation team they use.
Okay. The police persons gathered at the outpost, and when at around 7:30 a.m. the miscreants called up the victim's father, and not when, and that at around 7:30 a.m. the miscreants called up the victim's father, and the victim's father told them that he could not arrange the amount demanded by them, to which the miscreants told the victim's father to keep it ready by 9 a.m. on the same day, and that pursuant thereto, when the victim's father arranged the ransom amount and were heading to give the same to the miscreants, the police personnel followed and arrested 2 of the petitioners when they appeared at the said place to collect the ransom. Full stop. Thereafter, the police interrogated both the petitioners, and during the interrogation, the 2 accused persons named the other accused persons and all the 3 were resultantly arrested by the police personnel. Pursuant to the submission of the said charge sheet, before that, during the investigation, the police recorded the statement of the victim, that is namely Salman Ahmed, right? Salman Ahmed.
Salman Ahmed.
But his statement is very different before the police.
Yes.
Right? And no need to write that statement of Salman. But Salman said that those are miscreants who had actually, he doesn't know them, and then he was kidnapped, he was kept in one place, and then he was released. Thereafter, he came to know that father had given him so and so money. Right. But then there are affidavits. Where is
then we
that?
have never received the money. We have never received the money, the petition number 3.
Yes, this is what you say, but then the statements of Salman is different.
Yes.
And what about Moinuddin is one of the accused?
Moinuddin is the father of the victim.
Father of the victim. And he must have also, he has also stated the same. He had arranged the ransom. He was further directed on reaching so-and-so. Position to, okay. Then the special operation team. You try it during the charge framing or in the trial. Because see the accused statements and all, not a case for, I think, settlement.
Ladyship, in this case, the statement regarding the financial part,
Huh?
that the statement regarding the financial part, that has been, it is a 161 statement of the accused, that is at page 43.
43?
Yes, of Salman, who has lended money to the victim.
Salman's statement I have seen, this is second statement.
Yes.
No, this is accused 3.
Yes, accused 3. In this, he has stated that regarding so far as the financial part is concerned, or else so far as the statement of the victim and the party is concerned, there is no saying of the financial relation. But then so far as this statement of the petition 3 is concerned.
No, that is your case, that you had to get your money. But the fact remains, where is the settlement date? Huh?
Settlement date is of page 23.
Whereas the complainant on behalf of the alleged has filed the FIR due to some financial issue between the alleged victim and so who are both relatives, a misunderstanding arose, but the matter has been resolved amicably. Cordial relationship.
Ladyship, this compromise was executed only after the charge sheet was filed.
Where's the affidavit? Salman's signature is there in the agreement.
Yes, Ladyship. Page 24.
In his affidavit that he has filed, the deponent's signature is Salman and in the agreement it is Hussain. He sometimes writes Salman, sometimes writes Hussain in his signature.
Salman is on the left side.
Okay,
Hussain is the petitioner.
Salman. But this
First part is the complainant.
I'm not an handwriting expert, but they compare the signature of the Salman, it appears little different. Miss Pipi, you also see? Right. At page number 24 of the agreement and his signature in the recent affidavit. Acha. Okay.
Ladyship, in this case, the issue is purely private in nature.
No,
So
yes,
far as
but then, okay.
financial transactions concerned.
But then the fact is that before the police, Salman had stated he didn't even know he was going to his house. He saw a few, he didn't even say those were cousins. He said that few unknown people were going to his home. He went, met them, and then they took him to his place.
Because petition number 3 did not went to his place when he was picked up. Petitioner number 3, he was his relative, the Salman Hussein Ahmed.
Acha.
He did not go to his place when he was picked up. Only after he was brought to his place, there was a discussion that has taken place. But then, so far as the part is concerned, it has not been reflected. But the fact remains that they have settled the issue. At the residence of the council chairman was present.
He said some local persons, but you are saying that respondent number 3 did not go.
Yes, when he was picked up. Subsequently, the petitioner's family, they came to the council chairman's residence.
No,
And he was also
the
there.
agreement is also 2 pages, 2 paragraphs, without any further details. Right. At least some details. No, actually they went to get the money.
Your Ladyship, even the victim father has a pen his signature.
Victim's father?
Has a pen his signature in the
Has
compromise.
a?
The victim's father has also appended his signature in the compromise deed.
In the compromise date.
Yes. He was also present at the council chairman's place. Page 24. The thumb impression.
Had it been a family-related case or any further details in the agreement, matter would have been different. 2 lines agreement, and then so many allegations before the police. Those are only allegations, but try it during the charge framing. Right.
That has been framed. Charge has been framed, but then,
charge has been
yes,
framed.
trial is yet to commence.
Trial is
because
yet
of
to
this
commence.
pending case.
Settlement can also be gone through in the trial stage. Try there.
Lordship, if the matter can be,
Yeah, understand.
my only prayer is that if can be requested, because ultimately parties have entered into a compromise by settling the issue among themselves.
Try it during the trial. I'm not inclined. Okay, just write there. The petitioner, the victim in his statement before the police had stated had stated that on 12/8/2024, late in the evening, while he was about to reach his home, he saw some local persons proceeding towards his house. He as such followed them and reached his house. He further stated that those local persons asked for some water and took all their mobile phones and asked his name. And on being confirmed that he is Salman, they took him in a vehicle by blindfolding his eyes to an unknown place. He further stated that they beat him up and asked him about some black business. And that they kept on asking him about the same. He further stated that later, on the next day, the miscreants released him in a new location And on coming home, he found that his father had, coming home, he learnt that the said miscreants demanded rupees 2 lakhs for his release. The father was also examined by the police, Father was also examined by the police, and he stated that in the prior paragraph, you also write one sentence that the miscreants had called the father of Salman by the Salman's mobile phone. Then you go down, the father. The father stated that he got a call from his son's mobile phone, and that the caller on the other end said the person on the other hand told him to bring rupees 2 lakhs for getting his son back. The father as such went and informed the council's chairman and told him about the incident. He got repeated phone calls from the kidnappers asking for the amount. And when he arranged the amount, he went to give the same at a particular place, from where he was again directed to move to another place by the miscreants. And when he reached the particular place, the police personnel came and arrested the miscreants. Mr. Cho, right? For the petitioner states that the petitioners and the respondents, petitioners and respondent number 3 are related to each other, and stated that respondent number 3 took an amount of rupees 2 lakhs from the petitioner.
Petition number 3.
Petitioner number 3, with the promise to pay it back. And that on that day, that is on 27/8/2024, on the instruction of respondent number 3, the other 2 accused persons went to the house of the respondent number 3 to get the money back. And that the entire incident was only to get the money from respondent number 3, which was owed to the petitioner number 2. Petitioner number 3. He further stated that an settlement was entered into between the parties, which he has annexed with the petition as annexure number C. And in the settlement, which was entered into on 24th day of August 2024, it was agreed upon by all the parties, including the father of the victim, that the FIR was lodged due to misunderstanding, and the entire incident revolves around an amount of money to be paid back to respondent to petitioner number 3. It was further stipulated in the FIR, in the settlement, that both are relatives and they have resolved to amicably settle the issues between the parties. The matter was listed, the present matter was listed on 17/7/2025, and this court had directed that since the present petition was not a joint petition and the victim was arrayed as respondent number 3, an affidavit was directed to be filed by respondent number 3 in view of the settlement reached between the parties. In compliance of the said order, respondent number 3 filed the affidavit on 21/7/2025 by stating inter alia that he had taken an amount of rupees 2 lakhs on different occasion from petitioner number 3. With the promise to repay back, however, he could not give back the said amounts in time. He further stated that petitioner number 3 had sent his friends to his home on 12/8/2024, and he was picked up and taken to his place. Wherein he stated that he and petitioner number 3 had a discussion and that he agreed to give back the aforesaid amount. Full stop. He further stated in the affidavit that since he was not in a position to repay the amount, petitioner number 3 called up his parents and told them to arrange the money. So this is kind of the statements that he has made here. That also has some criminal liability. No? Because he is saying that yes, he was picked up. He was told to give the money. He couldn't. Parents was called and then he was asked to give the money. Parents came and gave it in the junction. So there is a criminal liability here. So let it be settled in the trial. Okay, then what? Money, arrange the money and hand it over on the next day at Vihoku, same one, Vihoku village junction. The respondent further states that his parents did not know about the financial dispute, and that thereafter when the petitioners were apprehended, the family members of the petitioners came for a discussion to the residence of Council chairman, and in the said discussion, all the parties decided to forgive the acts committed by the petitioner. And that a compromise deed was entered into. Full stop. Miss So-and-so has Miss
S. Mary PP.
S. Mary, right?
S. Mary.
M-E-R-I.
M-E-R-E.
M-E-R-E, Mary?
Yes, Mary, yes.
Okay. Otherwise, it's an easy name, but the way I hear it, it seems difficult. Miss Mary, the learned public prosecutor, had stated that the incident in question is a serious offence, inasmuch as the respondent number 3 was picked up from his place and was confined in a place, picked up from his place and was taken blindfolded to another place wherein he was kept confined, and money was demanded through the father of respondent number 3, to which the father arranged the money after much efforts and went to give the money to the petitioners, and in the process the petitioners were arrested. She has such stated that the offence under 64(2), right? 64 subsection, offence under 140 subsection 2, read with section 3 subsection 5
BNS.
of the BNS 2023 is well attracted in the instant case. She has placed reliance on the judgment passed by the Honorable Supreme Court in the state of Madhya Pradesh versus Lakshmi Narayan, reported in AIR 2019 Supreme Court 1296, wherein the Honorable Supreme Court has reiterated that only in cases of minor nature or a civil nature or a matrimonial nature which do not result in public wrong may be settled. She has also placed reliance in the judgment delivered by the Honorable High Court of Madhya Pradesh in Saurav SOURAV Gurjar GURJAR versus State of Madhya Pradesh, wherein the Honorable High Court had stated that cases of heinous nature like abducting, a victim from a public place and assaulting him may not be settled on compromise. I have heard the counsels for all the parties. It is noticed in the FIR, as mentioned above, that the victim it is noticed in the FIR above, lodged by the chairman of Lotovi Village Council, that victim was kidnapped by unknown miscreants from his house in an alto in a vehicle and was taken to a place. That blindfolding him is not there in the FIR, right? It is in the charge sheet.
That part is not there in the file.
So and so. And that the miscreants demanded rupees 2 lakhs, which was directed to be delivered at Vihoku Village Junction. It is reflected in the charge sheet mentioned above that that respondent number 3 was taken blindfolded, was picked up from his house, and by blindfolding him, he was taken by the kidnappers to a different place and was kept confined in the same. It is also noticed that from the said place, phone calls were made by the miscreants to the father of the victim, demanding rupees 2 lakhs, to which the father conveyed his inability in the beginning. However, on repeated phone calls for payment of the same, along with the threatening that his son would be released only thereon, the father somehow arranged the money and went to the place to hand over the same as directed by the kidnappers. Full stop. Till then, the kidnappers were not known as to who they were. When the father went to hand over, when the father reached the place to hand over the amount, the police personnel who were informed prior reached the place and apprehended the kidnappers. Initially, the police apprehended 2 of the kidnappers who, on interrogation, revealed that they kidnapped the victim on the direction of petitioner number 3. And that thereafter, petitioner number 3 was also apprehended. The respondent number 3 in the affidavit filed on 21/7/2025 in pursuant to the court's order had also stated that the victim was picked up and was kept confined at a place and the money was demanded, and that when he was unable to pay the same, when he expressed his inability to pay the same, phone calls were made to the parents of the respondent, who finally arranged and paid the money. Even though respondent number 3 in his affidavit had said that a settlement was reached between the parties, but the criminal liability of the petitioners, I will say this will not have effect in the trial. You must be thinking on that, okay? Criminal liability is writ large in the said affidavit of the petitioners are writ large in the said affidavit. As such, this court is not inclined to quash the FIR as well as the charge sheet or the subsequent proceedings. The petition is dismissed. However, the findings of this court will have no effect on the trial of the case. Petition is disposed of. Otherwise, I'm here to give relief, but then I couldn't in this particular case. So, try it during the trial, you might get it. Yes.
For orders, item number 26.
26. 26 is for orders. Yes, Mr. Sharma. You were there yesterday, or you went back and came back?
No, my guy, I stayed here.
Oh, you stayed here. This is
my lord.
fresh steps not taken. It is reflected in the office note. Fresh steps upon respondent number 2 not taken. On 23/4/25, of course. Oh, this is quite back. The Counsel for the praise for listening to which list this matter on 22/7. Respondent number 2 is appearing or what?
Respondent number 2, the suit also was proceeded ex parte.
Achha. There also he did not appear.
And even in the first appeal, no.
Oh.
And this is second appeal. And the appellant, who is the plaintiff, has filed 2 applications. One for amendment of the claim and one for appointment of a commission. That is come up for hearing, is possible.
Oh, but of course, respondent number 2 steps had gone initially, and then the report came that addressee cannot be located. Then again, affidavit is filed by you, I think. You are for respondent number 1.
Yes.
And fresh steps upon Iman is not taken, respondent number 2. So, respondent, why don't you take the Dusty will not do, right? Cannot be located. He's not there in his place.
Yes.
Can you do it by Dusty or by paper publication?
No, let me say, in the appeal, we have taken steps, right? Publication in paper.
Acha, you had already taken once.
Yes.
Acha.
Matter proceeded ex parte.
Oh, during the...
In the appeal.
Before the trial court?
Before the trial court also, in the first appellate court also, and in the second appeal also.
Acha. He is an accessory party otherwise?
As far as you are concerned, it's proceeded ex parte.
It's proceeded ex parte. But the fact remains in the office note, you can see it for yourself. Office note says fresh steps not taken. So you have to take the fresh steps. And if it again comes like this, then we can proceed.
My lady, if I may, since the dispute is between the plaintiff, the appellant, present appellant and me, who was the defendant number 3 in the suit, the 2 IS may be dealt with today.
Acha.
If it is convenient for the
Okay.
Sonata.
What are the 2 IAs then? The IAs, first one is?
No, first one is 204, your Lordship, kindly take up. It is for the amendment of the claim.
204.
204. 204, my lord, we have filed the suit for for declaration of our right title interest and setting aside of the order passed by the government, restraining order passed by the government against us. And that and the facts are like this, my lord. We purchased a plot of land measuring 2 kotha 16 acres from one Key Mure. Key Mure land was settled by the government at that time. After purchase of the land, we got the settlement, we got the pata, everything was there. And thereafter on 3/6/2003, government passed an order for cancellation of my mutation and restraining me from entering into the land.
Is it PWD colony? No, no?
No. Dankan Basti. Restraining me from entering into the land. Thereafter, I filed a case before the government, and ultimately the High Court held that you go to the civil court and get appropriate relief. Then we filed the civil suit. In the civil suit, my lord, we have stated the all things in the plaint. But in the plaint, the defendant number, the respondent herein, who is the defendant number 3.
Respondent here means which long time appears?
Apong from Guinea. Respondent number 1, who is the defendant number 3. He claims that he purchased the land from the defendant number 4. So ultimately the suit was decreed in my favor.
You also say you had purchased it from defendant number 4? He also claims?
No, I purchased it from one T. Mure.
Achha, okay.
He purchased the land from the defendant number 4. Thereafter, the
suit was decreed in your favor?
My favor. And in the appeal, it was reversed.
Achha.
And against that, we have to practice it.
Okay.
Here, my amendment of the plaint is very short and simple. In our plaint, there is some bona fide mistake of the advocate.
No, I'm yet to understand. Plaint is disposed of. Decreed, it was in your favor.
Yes.
Then again, you want amendment of the plaint?
Amendment of the plaint, I have filed in the second appeal.
Oh, achha. Can it be done at this stage?
Yes.
Achha, that I'm not aware. You have to show me the law. Then?
Then the amendment I only sought for to insert the schedule in the plaint.
Achha.
Schedule I ought to have amended, inserted the plaint. That was by mistake not inserted.
But a plaint without a schedule, how was it maintainable? It was.
It was maintainable, suit was decreed.
Achha.
There is a judicial court order. Well, to that effect, the defendants had also raised objection, there is no schedule, as required under Order 7 Rule 3. The issue was framed, issue number 3. That issue was decided in my favor by the trial court. That the schedule is not necessary, as required under Order 7 Rule 3. But the lower appellate court held, no schedule is necessary. Therefore, in the second appeal,
on that ground, it went against you?
On that ground, that went against me, as well as on some other grounds.
Okay.
Therefore, I want to induct the schedule in the plaint.
Oh. This is the IA is all about.
And whether if this amendment is allowed, it will not change the nature and character of the issue.
No, this will not. No, the fact. It is a fact about the schedule. Schedule means bounded by so and so, so and so. That part.
Yes, yes.
Ah. Description of the land.
Description of the land was not there in the plaint.
Hmm.
That may be allowed in the second level also.
So, what objection you have?
It cannot be allowed.
Oh, acha. At this belated stage.
The law
perhaps.
does not permit it. I'll show. But if you ask me,
Okay, let him finish that. This is the limited prayer you have.
Yes. That is one idea. Other idea I have question.
Okay. So, as far as 204, you have finished your argument or what?
What they have said because I have some Supreme Court judgment wherein it is stated that in the second appellate stage also plaint can be amended. The court's hands are not tied by granting relief to the litigant.
Show me those judgments then.
You will also kindly take this 2000. This is the person.
Vasantha, paragraph. At any stage of a suit, even at second appellate stage.
Yes.
But then again, what amendment is permitted? That has to be seen again.
I want to introduce the schedule of the land.
On that I know, but according to this case, what is paragraph 54?
Yes.
Any kind of amendments are allowed.
Yes.
Adverting to the present unprecedented is was in possession of the suit. Here the issue was different. Here, after the person died, there was no attempt to made by the original plaintiff to amend the plaint to seek the relief. It is a subtle law that amendment of a plaint can be made at any stage of a suit, even at the second stage. But in your case is a schedule.
No matter the principle either in the case, whether in second appellate court, the court has a power to amend the plaint. Here in his judgment, it is held that in the second appellate stage also, the High Court has a power to amend the plaint. That point is very limited.
Another case is referred, 81 supplementary SCC.
Yes. 81 supplementary SCC.
Okay.
Yeah.
This is 81 supplementary. Huh. Here, of course, the Act provides as
No,
such.
it is Act provides.
But then
Power
still
of the
it is.
High Court.
Hmm.
Supreme Court has said the High Court is a power to amend. That point is limited.
So that the matter can be decided finally.
Yes. And this is another judgment. Malappa and others. Supreme Court. Your Lordship, and to page, and to paragraph 23.
Unless there is some malified and then in that
There
case.
there is no malafide. There is a land, but by bona fide mistake it was not inserted in the plan.
Whether that can be a bona fide mistake, normally it is always.
That may be a bona fide mistake because the trial court it was not trial court advocate they sometimes misunderstood or something like that. Of course, there is another thing. A issue was raised. Issue number 3.
You said.
Issue number 3 that was decided in my favor.
That not required for the
Not
adjudication.
required. That issue was reversed by the appellate court. Therefore, it has become necessary to amend the plan. If it is your appellate court so held that the civil property is not property, justice is not a material defect, then I may not find this subject.
Okay.
These are the some
It's okay, this will cover.
another the Supreme Court in another decision held that where the amendment should be allowed. This is the decision. Life Insurance Corporation versus Sanjay Filters. So let's see, kindly turn to paragraph number 70. Where the amendment should be allowed. Yes.
The judgment is by Padliwala.
Yes.
Okay. If it does not cause prejudice to others, then amendment of the plaintiff is maintained.
If it is high on the insertion of the plaint, high on the schedule of the plaint, that cannot cause any
Prejudice.
to the adversary, because I am not changing the nature and character of this. My state is there, statement is there, that will be there. And I purchased the land, that was also mentioned in the plan. But due to some mistake, schedule was not mentioned in the plan. What is the, and my Lord, your Lordship, our High Court also, the Lordship can simply judgment for the act.
But if it has the effect of bringing new cause of action, then of course it will not be allowed. Better particulars, okay. Okay, enough for the I. Let him hear the other side.
These two should
So many judgments, huh?
Our High Court.
Yes, yes.
Yeah, please,
It's okay.
there's no dispute, Your Lordship.
Yeah,
that
one
even-
second. I'll just write his judgments. Yes.
There's no dispute
Huh.
that in appeal, even in second appeal, if it is justified, it can be amended. But the provision that deals with amendment, that is Order 6 Rule 17, was amended in the year 2002.
Acha.
Kindly see the provision.
Just give me this CPC. CPC.
CPC.
That day I had taken, I think. That day you had given me CPC, I had taken once. One must be in the file.
Order 6 Rule 17.
Yes, order
6 Rule 17.
Order 6, Rule 7, yes. Departure?
Order 6 Rule 17, amendment of
17.
17, 1-7.
Oh, acha. 7 is departure. Okay, 17. Yes, amendment of pleadings.
The court may, at any stage of the proceeding, allow either party to alter or amend its pleadings in such manner and on such terms as may be just. And all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. So, appeal also is a continuation of the suit. So, but the proviso, provided that no application for amendment shall be allowed after the trial has commenced.
Acha.
Unless the court comes to a conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial.
Okay.
This, now, Your Honor, Your Lady may also see Order 7, Rule 3.
Immovable property.
Where the subject matter of the suit is immovable property, the plain shall contain a description of the property sufficient to identify it. In such cases, in case such property has been identified, the boundaries or numbers in a record of settlement or survey, the plain shall specify such boundaries or numbers.
That is what mandatory requirement.
This is required. Now, what happened was, now after this amendment, the proviso says, yes, it can be done, but not before the commencement. It has to be done before the commencement of the trial. But in case, in spite of due diligence, they could not do it. Here, when we file a WS, the registry will only see the table book page 33
Of the second appeal.
of the second appeal.
Page 33. Just give me this.
Table book.
Oh, page 33. Someone had also reheard.
Paper book.
Huh. Yes. Yes, paper book. Page
33.
Yes.
Paragraph 3.
Paragraph
3.
3?
33 is the WS.
I don't know. This is one paragraph. Second appeal 1, right? Of
Second appeal 1.
2020. Paragraph 33 does not
No,
contain.
page 33.
Page 33 does not contain paragraph 3, whether it's a
That's
written
not-
statement, I'll see. It is a written statement only. Yes, written statement of defendant number 3.
Yes.
Yes, you are defendant number 3 then.
Yes. Paragraph 3.
Paragraph 3. Liable for non-description of the suit land.
The suit is liable to be dismissed from non-description of the suit land.
Yes.
So therefore, in the first instance itself, we took the objection. But they chose not to amend it.
But issue number 3?
No, I'll come to that. I'm saying in the WS itself, in the written statement itself, we objected. We said that the suit is not maintainable because it has not been described there.
That is why I said in the beginning how it was maintainable.
So-
but let me see.
Therefore, here the issue is only in spite of due diligence, they could not amend. They could not do that. So they were only then the court can allow once the trial has commenced. Now, before the trial commenced, even in the WS, we took this objection, but they decided not to amend it. They said it is enough. We have described it enough.
Oh.
So they chose not to do it. Therefore, the due diligence will not come into play.
Will not come.
They knowingly did not amend it. Knowingly did not do it. Issue was framed. One of the issue, 73 page.
Page 73.
73. Issue number 3.
Again, the pages might not tell you here. It's not telling. Issue.
Page 73. In the table, it's page 73.
Issue, no, it is 77, I think.
Oh.
Wait,
Issue
wait,
number
wait.
3. Whether the suit is liable to be dismissed for non-description.
Non-description.
of the suit land.
This issue was framed where?
It was framed in the suit.
Learned trial court only?
Yes, trial court. So therefore, this also was an issue. Because we had raised that objection, that the suit has not been described in the plain. And they said no, issue is framed. Yet they decided no, it is not needed. Raised the question of due diligence, is negligence, or they decided not to, and said that it's sufficient. My plaint is properly done, land has been properly
And what is the
described.
finding on this issue?
Trial court says it has been
Properly described.
properly described, so therefore schedule is not required. First appellate court said no. There is also one of the grounds, one of the finding that it is required. Now, can we see the decisions, rulings on this point? Before I go into the rulings, my lady, can kindly see the application, IA 204. I've also filed a detailed objection. Kindly see the reason why, the reason they have given, paragraph 4.
Wait 1 second. These are judgments.
204.
In their petition.
Their page.
Yes, what? Which page?
Paragraph 4.
This is affidavit in opposition.
204.
One second.
I have 204.
Yes. Which page?
Paragraph 4, page
Paragraph 4. Okay.
The reason given that in the plaint, due to the bona fide mistake of the advocate, the schedule of the property was not specifically mentioned as required under Order 7, Rule 3 of the CPC.
But this cannot be the ground because they have already said we have described. And the court agreed. Now, by taking a different turn, you are saying that there was a bona fide mistake.
No, but the trial court held in favor of the plaintiff.
That's not required.
Not required.
Because they have adequately yes.
Described in the plaintiff.
But then now this ground.
Because the appellate court set aside death pending.
But then you should have taken that. No, we have explained.
No, that point was argued.
What the appellate court
That point was argued before the lower appellate court. But the lower appellate court did not consider that point, and they set aside the reverse the finding on issue number 3.
Okay.
Therefore, it has become necessary to incorporate the schedule of the schedule in the plaintiff. Because trial court here is not necessary, it is okay. Lower appellate court is necessary. Therefore, we have had this application to incorporate the schedule in the plaintiff. Whether that will change the nature and character to so. Therefore,
Okay, let him finish. I'll go to you. Then?
My lady,
Yes.
what the trial court said, what the first appellate court said is not important, but what Order 6 Rule 17 says. Now, this judgment that I'll be submitting
Yes.
will clear the matter. First is,
Rajkumar.
yes, Rajkumar. Can you now listen? The leadership will kindly come to the first one, 2008-14 SEC, paragraph 12. In order to consider whether the appellant has made out the case for adjournment of his claim, is put before the Order 6 Rule 17 CPC. We will skip this part. The first part of the rule makes it abundantly clear that at any stage of the proceeding, parties are free to alter or amend their claims as may be necessary for the purpose of determining the real portion in controversy. However, this rule is subject to proviso appended therein. The said rule, the proviso again substituted by the Act of 2002, with effect from 1/7/2002, makes it clear that after the commencement of the trial, no application for amendment shall be allowed. However, if the parties to the proceedings are able to satisfy the trial, that in spite of due diligence, they could not raise the issue before the commencement of the trial, the court is satisfied with the explanation, amendment can be allowed even after the commencement of the trial. 13. To put it clear, Order 6 Rule 17 confers jurisdiction on the court to allow either party to alter or amend his pleadings at any stage of the proceeding on such terms as may be just. Such amendments seeking determination of the real portion of the controversy between the parties shall be permitted to be made. E-trial amendments are allowed liberally than those which are sought to be made after commencement of the trial. As rightly pointed out by the High Court, in the former case, the opposing party is not prejudiced because he will have an opportunity of making the amendments sought to be made. In the latter case, namely after the commencement of the trial, particularly after completion of the evidence, a question of prejudice to the opposite party may arise, and in such event, it is incumbent on the part of the court to satisfy the condition prescribed in the proviso. 14. With this background, let us consider the application filed by the plaintiff and the order passed by the district court as well as the High Court. We have already stated that originally the suit was filed against sole defendant and subsequently second defendant came on record as per order that is. In this case, the plaintiff and that his absolute honor of the suit is scheduled. It is not the dispute that prior to filing of the suit, notices were exchanged between the parties. In the reply, there is such, the plaintiff's notice specifically asserted that the first respondent hearing, namely such as so-and-so, is carried on by activities in the suit. The perusal of the reply notice issued by D2 plaintiff, which has been extracted by the High Court in the written order, clearly shows that the plaintiff has once made known that the suit land was in possession of D2, having taken them on lease from the government. With the said information in the reply notice about the money being carried out by D2, the plaintiff filed a suit without pleading for possession and damages. Now, finally come to 16. As rightly observed by the High Court, it is explicit from the written statement filed by D1 that the plaintiff was made known of the fact that the government issued order transferring mining lease held by such and such in favor of so-and-so, and the leased lands are in possession and enjoyment of so-and-so. As rightly pointed out by the non counsel for the contesting respondent, in spite of plaintiff being put to knowledge of the act, the person in possession of the suit property did not choose to complete this set and such and such, which came on record on his own application as D2 in the suit. It is clear that in spite of reply notice and specifically taken in the written statement of D2, the plaintiff did not choose to take steps to get the claim amended suitably, and instead allowed the suit to go on and examine the cases on his behalf and cross-examine the cases produced by the defendant. Only during the stage of argument that plaintiff came up with of the application under order 6-17 seeking amendment of the case. 17. We have already clearly explained the application of provider to Rule 17. Though even after commencement of the trial, parties to the proceedings are entitled to seek amendment. In the light of the factual details, such a clear information will be filed in notice prior to the filing of the suit, and specifically in the written statement of B1, which contains details of government orders listing of the suit property in favor of B2. The action of the plaintiff at the stage of argument cannot be permitted. Immediately the plaintiff failed to alert the suit because of appropriate time.
Okay, in spite of knowing they did not do so.
It's part of knowing, pointing them out that this is the defect, there's a defect there. In spite of framing issues, they allow. Now the suit was defeated in their favor, they were happy, there never is, we filed an appeal, they never received it before the first appeal, first appellate court. It's a second appeal, my lady. Only questions of law here. Things that has not been urged in the court below cannot be urged here. And now, this application was filed during the final hearing of the second appeal last year. The hearing had concluded, they had made the submissions. I started my submission, and on the next day, I had to continue the next day. They came with this application. Now, the other two judgments are also very clear. Just the other one, 2009, 2 SCC 409. Further 10 minutes. The matter before the commencement of the trial. From the other cause by the United Trial Court, it is evident that the respondent had not been able to fulfill the set condition. The question, therefore, which arises for consideration is as to whether trial had commenced or not. In our opinion, it did. The date on which the issue are framed is the date of first hearing. Provisions of Code of Civil Procedure and this taking various steps at different stages of the proceeding. And filing of affidavit in view of examination, in our opinion, among the commencement of the case. Here, there is no dispute here. Here, though, the second appeal. And we continue. With paragraph 19. It is the criminal duty of the court to decide as to whether such an amendment is necessary to decide real dispute within the parties. Only if such a condition is fulfilled, the amendment is to be allowed. However, provision appended to Order 6-17 of the court restricts the power of the court. It puts an embargo on exercise of its jurisdiction. The court's jurisdiction in case of this nature is limited. Thus, unless jurisdictional fact as a necessary is found to be existing, the court will not have the jurisdiction to allow amendment of the claim. Then, my lady, the last one, just 2 paragraphs. 2012. 2 SCC 300. Marriage for paragraph 8 onwards. Here the facts also is little similar, so everything will be clear. Based on an agreement that is such and such, we release to the son of 3 years, the secretary is also for the consideration of such and such. The respondent will file the suit on specific documents. Since we have already mentioned the factual details, there is no need to refer to same, except in the details related to the petition filed under Order 6-17. After the filing of the written statement by the contesting defendants, the trial of the suit commenced and immediately brought the party to produce evidence on their behalf and argument on behalf of both the sides were heard and completed on 22/19/2010. On that day, the court reserved the matter for hours. Meanwhile, on 24/9/2010, the respondent will file a petition claim for amendment of the claim. In support of the said application, plaintiff 2 has filed an affidavit stating that in paragraph 11 of the claim, he has stated about the legal notice issued on such and such defendant number 1 to 7 for specific documents of agreement of same such and such, and there was no reply from him. In paragraph 3 of the affidavit, the respondent has stated that by a typing mistake, the following sentences have been missed. Typing mistake. after paragraph 11, you can see this. The only reason given by the plaintiff claim for amendment and inclusion of the above amendment in the claim is a typing mistake. It is also stated that it happened in spite of due diligence. 10. The above claim was resisted by the appellant claim by filing a detailed counter affidavit. Apart from disputing the merit of the claim of the plaintiff, with regards to the petition under Order 6 Rule 17, they specifically stated that after passing several stages in the protected trial, the final argument of the plaintiff in the suit was heard on 29 2010. The defendant had also filed a statement on 22/9/2010, wherein the inherent defect of the claim there is absence of averment, same here. Averment, a mandatory requirement of sections such as such of specific related act, and form number 7 of such as was pointed out. Even after this, further argument was made by both the parties, and the counsel for the plaintiff informed the court that no further time is required, and the matter may be posted for arbitration. In view of the same, the learned trial judge posted the matter on such as such as judgment. Only at this juncture, that is on 24/9/2010, the plaintiff came up with the present application seeking amendment of the incorporate specific pleadings in the
Type mistake.
CPC on the ground that the same was dismissed due to typing mistake in spite of due diligence. The court, though the said claim was not acceptable to the trial court, the High Court allowed the plaintiff to amend the claim. 11. Before considering the acceptability of other or otherwise of the reasoning of High Court, it's useful to refer to Order 6, so we can skip this. Then 13. After a stiff resistance by the latter case, the members of the bar again, this is regarding the amendment. So again, Order 627 was introduced with proviso appended therein. As per the said proviso, no petition for amendment shall be allowed after the trial has commenced. However, there is an exception to the said rule. If the court comes to a conclusion that in spite of due diligence, the party could not address the matter before the commencement of the trial, such applications for amendment will be allowed. Before proceeding further, it is also useful to, you can skip this. 15. In this little background, we have to once again recapitulate the factual details. The case on hand, suit number such, after prolonged trial came to an end in September 2010. The application for amendment under Order 6 Rule 17 was filed on 24/9/2010. That is, after arguments were concluded on 22/9/2010, and the matter was also for judgment. I've already mentioned Section 16 of the Stability Act contemplates specific elements have to be made in the claim that he has performed and has been willing to perform the essential terms of the Act, which have not been performed by him. This is an essential ingredients of Section 60C and the form prescribed for the documents. The proviso inserted in Rule 70 clearly says that no amendment shall be allowed after trial has commenced, except when the court comes to conclusion that in spite of due diligence, the party could not address the matter before commencement of the trial. As stated earlier, in the present case, amendment application itself was filed on 24/9/2010 after argument were completed and the matter was posted for judgment on 4/10/2010. A proper interpretation of proviso Rule 17 of Order 6, the party has to certify the court that it could not have discovered the ground which was pleaded by the amendment. In spite of due diligence, no doubt Rule 17 confers power on the court to amend pleadings at any stage of the proceeding. However, proviso restricts the power once a trial has commenced. Unless the court satisfies that there is a reasonable cause for allowing the amendment, normally the court has to reject such a request. An argument has been advanced that since the legal notice sent before the filing of the suit, there is a difference of regulations and legalings that the plaintiff has also led the agreements not to include the court from examining the said application, which we are unable to accept in the light of Order 16 of the specific as well as Order 6 Rule 17. The only reason that is stated from an affidavit is omission of type mistake. Evidently, it is not an omission to mention the word or arithmetical number. The omission is with reference to specific key which is mandated in terms of Orders Section 16 of the specific related. The primary aim of the court is to try a case on merit and ensure rule of justice prevails. For this, it needs true facts of the case to be placed before the court so that the court can assess all the relevant information informing this decision. Therefore, at times required to permit parties to amend their claims. The court's discretion to grant permission for a party to amend the pleadings lies on two conditions. Firstly, no No injustice must be done to other side. Secondly, amendment must be necessary for purpose of determining the real question in controversy between the parties. However, to balance the interests of parties in the pursuit of justice, injustice, the professor has been able to clearly states that 19 Malay. Due diligence is an idea that reasonable investigation is necessary before certain kind of relief are requested. Due diligent efforts are required for the parties to seeking to use adjudicatory mechanism to attempt an anticipated relief. An advocate representing someone must engage in due diligence. Valerie, can you see? They said advocate mistake. An advocate representing someone must engage in due diligence to determine the representation made are factually and sufficient. The term due diligence is specifically used in the court so as to provide us a test for determining whether to exercise the discretion in the situation of the requested amendment after commencement of the trial. A party requesting a relief stemming out of a claim is required to exercise due diligence, and it is a requirement which cannot be dispensed with. Then the term due diligence determines the scope of a party's prospective knowledge when it is very critical to the outcome of the suit. In the given facts, there is a clear lack of due diligence, and the mistake committed certainly does not come within the purview of typographical error. The term typographical error is defined as a mistake made in printed typing material during a printed typing process. The term includes error due to mechanical failure of slip of hand or finger, but usually excludes error of ignorance. Therefore, the act of neglecting to perform an action which one has an obligation to do cannot be called as a typographical error. As a consequence, the plea of typographical error cannot be entertained in this regard since the situation is less of due diligence when such amendment is implicitly barred from the the claim of typographical error mistake is best and cannot be accepted. It's baseless and cannot be accepted. In fact, had the person who prepared the claim signed and verified the claim showed some attention, this omission could have been noticed and rectified there itself. In such a secondary success, it cannot be considered that due diligence was added to, and in any event, omission of mandatory requirement running to be 3 to 4 sentences cannot be applied to full error as given by the plaintiff. All these aspects have been widely considered and concluded that a trial court on the High Court has committed error in accepting the extension that is a typographical error to mention it. Number 48.3, though the Counsel for the Appellants have cited many decisions on balance rate, we are of the view that some of those cases have been decided prior to the insertion of the Order 6 to 17.
When was it inserted?
2002. 2002. We published, and the suit was filed in 2004. We proviso or on the peculiar facts of the case. This court is in various decisions upheld the power that in reserving cases the court can allow delayed amendment by considering the other side by awarding cause. The entire object of the amendment of Order 6 to 17 as introduced in 2002 is to stall filing of application for amendment in a place subsequent to commencement of the trial to avoid surprises that the parties have sufficient knowledge of the other case. It also helps to delay in filing application. Very clear.
Yes. Okay, at 2, rest at 2. Yes. Mr. Longzam, you have finished? On 204.
204.
Okay. Now you will reply.
Very short reply.
Hmm. Now, one question, Mr. Longzam, whether that will prejudice you?
Of course.
It's only the schedule bounded by this,
But
that, this.
Even then,
Huh.
whether it's permissible or not, that is the main issue. The law does not permit.
Even if it is, okay, you have shown the proviso and said that
And
it's
I've
not.
always been taking this plea that
Hmm.
the suit is not properly described, and therefore,
Hmm.
from the
Yes,
ve-
you have
from,
made
from
in the.
from the initial stage,
Hmm.
I took this down. This was an issue
Hmm.
which was decided against me. I took it to the appellate,
Hmm.
first appellate court decided in my favor.
Hmm.
So obviously, it is allowed now. We do this way. And whether that can be done, it cannot be done.
The amendment.
Because prejudice part, even if it can be done, in one of the decisions that he had cited, it said if it does not cause prejudice to the other party, then.
Even if we say that due to due diligence, if they are able to show due diligence, it should
yes.
not prejudice me. But here, where's the due diligence? Deliberately chose not to do it.
And that shows they were deliberate. Otherwise, they would have corrected the moment you have brought it to the notice. Yes, they okay? They reply?
Well, my reply is very short. The amendment which I have sought incorporate the schedule. Whether that incorporation will change the nature and character. Amendment generally rejected when the nature and character of the suit is changed. If your lordship see on the incorporation of the schedule in the claim, whether that will change the nature and character of the suit. My submission before your lordship is this: it will not change the nature and character of the suit. Therefore, amendment short form is to be allowed.
But whether that will go beyond the prohibition as provided under the proviso?
No, the judgment I have given you, what's LIC versus Sunday Builders.
LIC.
is this paragraph 7. Here the Supreme Court has very specifically stated that all amendments are to be allowed which are necessary for determination of question.
Which paragraph?
Paragraph 70.
70 is the conclusions. Yes.
Our final conclusion.
Which are necessary for determining the real question in controversy.
Yes.
Provided it does not cause injustice or prejudice to the other side.
Whether
I'm sorry to interrupt, but when was the amendment so that day in this judgment? Because
This was
the
only
date is
during the proceeding of the second.
2002 is the amendment.
to that effect, I have filed 2 3s as well. The High Court has the 12 power.
At any stage it can be. But provided it does not cause injustice or prejudice.
Whether your also is to see whether insertion of the schedule in the plate, whether that will cause injustice to them
Or prejudice.
or prejudice. It is not, because my plate I have already mentioned the tag number, patra number, everything there. And only that point I have to state it in the schedule of the plate, which is under the requirement of law. And the issue number 3 was when that was decided in
No, if you say that everything was incorporated, then what is the necessity of making this?
Order 7 Rule 3 is there. That is
That means you have violated.
that is the requirement of law. That the schedule of the property is to be mentioned.
That is what.
That was not mentioned. Whether that non-mention of this should be a matter. Therefore, in this section, the amendment does not result injustice to the other side. Amendment to the party seeking amendment does not seek to withdraw any clear admission by the party. The amendment does not time bar. The prayer for amendment is generally required to be allowed unless by the amendment time bar claim is not in our case. Amendment changes nature and character, so it is not our case. Prayer for amendment is valid, it is not our case. By the amendment or otherwise loses the valid defense, it is not their case. In dealing with the prayer for amendment within the court should avoid the hyper-technical approach and ordinarily required to be liberal, especially where the opposite party cannot be compensated, can be compensated by cost. The amendment would enable the court to frequently consider and they would rendering more satisfactory decision in the prayer for should be allowed. Where the amendment merely sought to be introduced an additional or new approach without introducing a time-bound cause of action, the amendment is likely to be allowed after the expiry of the period. The amendment may be allowed to justify, where the intended to rectify the absence of the legal requirements. Delay in approaching the amendment alone cannot be a ground to disallow the prayer. Where it is accepted the delay is agreeable, the prayer for amendment will be allowed, and the issue of limitation fact separately in the decision. The amendment that changes the natural character of each other concern, that is. Therefore, I paragraph here watching the Supreme Court is very liberal in approaching the amendment of the PD. And what my learned friend is submitted the due diligence. That due diligence what has done by this system. There is
Not a statutory provision, how can it be said to be gone by?
No.
It is there.
No, that is by the
It has been interpreted.
Therefore, in our case, no new cause of action arise, no nature and character will change, and the real question of controversy between the parties. And whether the another part is this, right? The 45, it is, we have stated in our petition.
But these, okay, Order 6 rule, okay, huh. But these final conclusions, Order 2, Rule 2 operates as a bar, subsequent amendment or plea of amendment being barred under Order 2, Rule 2 is just misconceived and hence negative. Whether these conclusions...
My lady, my colleague, see when was the, in this case,
Roman 3
it was the various 2002. Law has changed after 2002. When was the amendment sought in this case? Because even if it does not cause prejudice to me, after 2002, there was no, they have to show that in spite of due diligence, after the commencement of the trial, they have to show that in spite of due diligence, they could not make the amendment. That is mandatory now after 2002. Before that, it was not there. Before 2002, it was not there. Before 2002, everything will be applicable. But now it is mandatory.
My lord, their part has already been concluded. If my last friend is started against arguing, then there will be no end. Argument, reply, then reply from the so far,
So this is your reply that it can be done.
Then for the fault of the advocate, the client should not suffer. That is the decision of the why the client is suffering for the fault of the advocate.
Okay, let me dictate the 204 first. I'll dictate the arguments. I'll take the decision in my chamber. And what is 205?
203.
203?
203 is this, my lord. We have prayed for issuance of commission.
Acha, okay, I'll deal with it later. First, let me deal with 204. Dika, this is an application. This is an... where is the application? Application, this is an application filed under Order 6, Rule 17. Read with, I'm hearing my own voice here. I'm hearing my own voice in this one. An application under Order 6, Rule 17, read with Section 151 of the CPC 1908, by which the applicant has prayed that he may be allowed amendment of the plaint by inserting the schedule to the copy of the plaint. That prayer is not there in the... Let's switch it off, huh? No, I'm taking up IS Civil, this one, 204, but prayer is not properly... No, it's okay. It is the case of the petitioner that the original plaint was filed before the trial court without the schedule as required under what rule?
Order 7, Rule 6.
As required under Order 7, Rule 3 of the CPC. Order 7, Rule 3. The petitioner further states that the said issue was raised during the trial of the proceeding, and an issue being issue number 3 was formulated as to whether, where is issue number 3? You have mentioned it in the IA? No, no? Page 73, right? Oh no, the page number is different. Wait, this is paper book. Whether the suit is it? Okay, I've got it. Oh, cha, cha. 73. What did I say? No, what did I say?
Page 127.
No, what did I write? Whether the suit is liable to be dismissed for non-description of the suit land. He further states, the counsel for the petitioner further states that in reply to the said issue, not in reply, the said issue was considered by the trial court, and the trial court observed that, now it is coming more. I can hear my own voice. So the trial court observed that there has been enough description of the land, the schedule of the land in the plaint, and as such, it was not required for a schedule to be appended there with the plaint. That was the reply. I'm not saying, I'm just dictating. Thereafter, upon conclusion of the trial, the judgment and decree also, judgment and decree was passed in favor. Judgment was passed in favor of the appellant plaintiff was passed in, and a decree was made. Agreed by the said judgment, respondent number 1 went on appeal before the first appellate court, and on completion of and upon hearing the appeal, the appellate court delivered the judgment in favor of respondent number 1. One of the issues that was considered by the appellate court was the absence of the schedule appended to the plaint. Against the said judgment and order, the plaintiff appellant has come before this court by filing the second appeal. During the hearing of the second appeal, the appellant filed the instant interlocutory application being IA number 204 of 2024, praying for a direction from this court to allow amendment of the plaint by inserting the schedule to the same schedule to the same. The counsel, Mr. A.C. Sharma, Mr. A.C. Sharma, appearing for the applicant, submits that due to bona fide mistake of the advocate, the schedule of the property was not specifically mentioned as required under Order 7, Rule 3 of the CPC, 1908. He further submits that the amendment of the plain can be entertained at any stage as has been held by the Honorable Supreme Court in a number of decisions. He relied on the following decisions. Number 1, Life Insurance Corporation of India versus Sanjeev Builders Private Limited, reported in 22 Live Law. Oh yes, the 22 SCC Online, SC 1128. Number 2, all Gauhati High Court. Mallava, MALLAVA, and another versus KAL Kalsa, MMANAVARA, Kalamma, KALAMMA, reported in 2024 SCC Online, SC 3846. Number 3, Rajendra Prasad versus Kayastha, Pathshala, Allahabad and others, reported in 1981 Supplementary SCC 56. Then Vasantha, through legal representative, versus Raj Lakshmi, reported in 2024 5 SCC 282. Then Sandha, SANDHA, Debi Thapa versus Anjali Debi Thapa, reported in 2003 2 GLT 368. Hafsa Khanam, HAF SA Khanam versus legal heirs of Amarendra Goswami, reported in 2018 1 GLT 500. Then Hafsa Khanam you have given 2 times. Achha. Okay, these are the cases. Well, by relying on the said judgments, Mr. A.C. Sharma submits before this court that the amendments which are necessary for determining the real question in controversy shall be allowed unless the same causes injustice or prejudice to the other side. It needs also to be allowed for effective and proper adjudication of the controversy between the parties. He also submits that when the amendment does not change the nature of the suit or cause of action so as to set up an entirely new case, the same must be allowed. He further stated that the amendment is not for any malified reasons. Full stop. He also stated that the description of the land was already there in the plaint. However, in consonance with Order 7 Rule 3 of the CPC, he prays for the addition of the schedule to the plaint, which was left due to inadvertence. As such, he prays that in the interest of justice, the description of the land as Schedule A may be allowed to be inserted in the plaint. That is all your submission. Mr. I. Longzem, appearing for respondent number 1, however, objects to the prayer made inasmuch as the same is not allowed.
File an objection.
Oh, yes. By filing an objection, he has objected by filing an objection to the instant IA. Or you can say Mr. I. Longzem had filed an written objection to the instant IA and has affidavit in opposition in the instant IA and has further submitted that the said amendment at this stage is not permissible under the law. He placed reliance on Order 6 Rule 17, right? Order 6 Rule 17. And stated that although amendment to the pleadings is allowed, but amendment of the pleadings is allowed, but the same is not permissible after the trial commences unless the court comes to the conclusion that the party could not raise the matter before commencement of the trial in spite of due diligence. Order 6 Rule 17 may be quoted herein below. No, not now, I'll quote it later. It's okay. So diligence. He relied on the decisions as mentioned herein below. Number 1, Rajkumar Guruwara versus S.K. Sarwagi and Company Private Limited, reported in 2008 14 SCC 364. Number 2, Vidyavai, Vidyabai versus Padmalatha, reported in 2009-2 SCC 409. 9-2 SCC 409. Number 3, J. Samuel versus Gattu Mahesh, reported in 2012-2 SCC 300. By relying upon this para, By relying upon the said judgments, Mr. I. Longzem submits that the Supreme Court has made it clear that after the proviso has come in 2002 or the entire
Everything was deleted once in
And
1999
proviso-
and brought back again in 2002.
proviso was inserted. What did I say? After the proviso to Order 6, Rule 17 was brought into effect.
This Order 17 was deleted in 1999
Deleted.
and then again brought back as a whole.
Whether the
Together,
is Order
with
17,
all
the
the judgment that have been read, it is set.
that after Order 6, Rule 17 was amended and brought into effect from 1/7/2002. No application for amendment of the pleading would be allowed after the trial is commenced, unless the party shows that they could not raise the matter in spite of due diligence. It was also held that although Order 6, Rule 17 confers jurisdiction on the court to allow either party to alter his pleadings at any stage of proceedings, but the terms has to be just, and such amendments would be considered liberally during pre-trial. However, after the trial is commenced, or after completion of the evidence, the question of prejudice to the opposite party may arise, and in such event, the court has to satisfy the conditions prescribed in the proviso, that is, due diligence. Mr. I. Longzem has further submitted that before commencement of the trial, when he filed the written statement, page 33, he raised the issue that the suit is liable to be dismissed for non-description of the suit land.
Which was the most famous issue.
Which culminated in framing of issue number 3 as stated above. As such, he submits that the applicant cannot raise the ground that in spite of due diligence, the amendment was not sought for.
Deliberately chose not to.
and he deliberately chose not to. It is his submission. He deliberately chose not to amend the plaint by adding the schedule thereof. And that the trial commenced and ended in judgment. He further submits that the said amendment to the pleadings, that is, addition of the schedule to the plaint, was not even raised during the first appellate, before the first appellate court. And it is only when the present second appeal was in the process of hearing for final disposal.
In my objection, I clearly said that. They even said that it is not needed either. They argued.
Okay. In the second appeal, what did I say? They raised it in the second appeal before the High Court. They raised the issue during hearing. Disposal. The applicant filed the instant IA for amendment of the plaint. What did you say? They have not? You had mentioned in the...
During the hearing of the first appeal, since this was one of my ground, they said, but the appellant, the plaintiff, said it is not required. Amendment description is not required. Same thing that they said before trial court.
He also submitted that although he raised the issue of bar in amending the plaint,
description of the
bar in adding the schedule to the plaint, in adding the description.
No, I said that issue number 3 was there, that it's not properly described. But they said it is not required, properly described.
Okay, he also had submitted that during the first appellate, before the first appellate court, he raised the objection. He raised the issue that the plaintiff had not described the schedule property, to which the plaintiff replied that it was not required, inasmuch as issue number 3 was answered by the trial court.
Sufficiently described.
And that it was sufficiently described in his plaint. These are your submissions?
Yes.
Heard learned counsels for both the parties? Now, even if what I have seen is that here you have initially before the trial court has said that no, enough description is made, it's not required. Yes. Now you are turning around and saying that it was a bona fide mistake. See, these are two different arguments.
That's right.
But whether...
No, there are decisions of the Honorable Supreme Court. The description is there in the plain. The description, schedule is not described.
No, you could have taken the same ground now. No, it is described, I need not. But you said that it was a bona fide mistake. Now let me allow me.
Yeah, that was a bona fide mistake of the error.
But that is totally different stand taken there.
Because at the time, the advocate inside the advocate argued the case. He also said that the...
But whether that will again, because you see, same land. He is also claiming title, you are also claiming title. Now whether same land bounded by same things, whether that will affect you now?
No, what I'm saying is, whether it affects me or not is a different thing, my lady.
But then not permissible.
It's not permissible. If the law does not permit, we have to satisfy we are bounded by law. Within that we have to act, within the parameters given by the law.
Yes, that of course is there, but then according to this...
He says it is all along, even in the while filing the second appeal, this was not a ground. Even only during the midst of the hearing when things were not going properly. Suddenly, in the midst of the hearing, final argument.
It is different thing at any moment in the Supreme
This
Court.
came, this came.
Because
this
I can
application
see one of our learned judge has written everything and the matter was already heard.
It was heard. It was heard. The final hearing was taking place. Appellants had concluded the argument. I had just started. And adjournment was sought. And suddenly this application came in the midst of the appeal, midst of the argument.
Acha, about that,
Now,
okay.
my lady.
Now, in fact, okay, by the provisions it is not permissible. But by this life insurance corporation case, where it was interpreted. And there are so many clauses.
My lady may kindly see whether the issue of due diligence has been discussed there or not. Whether the proviso was attracted in this case or not. That has to be seen. This case, I don't know. I have not read this case.
The proviso perhaps
when was the amendment sought in the suit? Here, that has to be noticed. When was the amendment sought in the?
I'll just see this is a small fact.
Yes, the facts has to be. It's very relevant.
This instituted for specific performance. In the alternative, paid for damages. Enhancement of amount. The plaintiffs moved the chamber summons seeking enhancement of the amount. Learned Singleton allowed the chamber summons, referred to keeping the limitation open. Just go through once this one.
Let me go.
Because otherwise,
I don't have a copy of the judgment.
Acha, this was the entire section was inserted again on 2002. And this is of 2022. Of course, the facts.
No. The case suit amendment. When was the amendment sought? What are the facts of the case?
Original suit is of 1986.
Can you see that? If I can just have this, I can just find out and go.
Just give him this, courtmaster. Because the suit was of 1986.
Yes.
This was before the amendment.
My lady, here the judgment I have referred. So there are many judgments, but all prior to 2002.
Well, your lordship can see this judgment. My trial court relied on this decision, held that the civil is non-issue.
While allowing issue number 3, what? Trial court?
By relying this judgment.
Trial court had allowed.
Trial court relying this judgment, holding that description of the property is not required.
Which paragraph? 11.
Headline,
No, headline not necessary. Paragraph 11.
Paragraph 5, 6, 11.
Again, see, by relying on this, you are again making your submissions twofold. You are saying not required. And then you are saying that inadvertently it was not put.
No, the trial court has stated by relying this judgment that it is not received. I am just pointing out your lordship that this is the judgment relied by the Supreme Court, by the trial court.
And this is, of course, they say that about rules, Order 7, Rule 3. Right, and then.
Now our case is different. Now I want to introduce this schedule in my plate.
But as such, you are not permitted by after the commencement, unless you show due diligence.
That is the power, inherent power given to the High Court, that even in the second appeal stage or the answer stage, amendment of the claim can be allowed. That is the principle of the amendment of the plea.
But I cannot go against the statute. I can go against the law. After the commencement, you have to show that.
I am not insisting on go against the statute. Your lordship is to go what the Supreme Court held in so many cases. Because the Supreme Court decision is binding on the lordship.
And apart from this, what you had shown also the so and so, but then due diligence part.
Maybe this citation is from
Huh.
live law. We need to see from the SCC online.
Yes, the SSC online is reflected.
But we don't know how
Party
it's
cannot be refused because of some mistake.
the facts are not mentioned properly. Is this was specifically there?
Or that by his blunder he has caused injury to his opponent.
Is this which?
Is it done?
In this Malavya case, it is said that unless the party was acting malafide or that by his blunder he has caused injury to the opponent, cannot be compensated. Amendment of plaint. Okay, I will decide. I will go through all the judgments.
This
Now,
judgment is very.
but 86, the original suit. And okay, I have written the submissions. I will go through and I'll pass the order.
Those judgments, maybe, that have referred.
Yes, yes.
So please say that rest in WS, not.
Yes, I will go through.
So far,
I'll just take up it. What is the second matter?
second matter is we paid for issuance of commission. We paid for issuance of further investigation of the suit plan, as well as for the recording additional evidence. They have filed affidavit in opposition, which we have received on 7/5/22. We want to file a objection on this.
Oh, in this, we will file your objection.
Reply.
Oh, where did the counsel go? Oh, acha. Okay, here I'll just see the last order, what had happened. Okay, in this you want some time to file a reply. In the other you say, provided of course he wants time. In the other you say that the 203. This is an application file for what? For
issuance of commission. Under order 26.
For issuance of commission under order 26 rule 9.
Rule 9. Reduced section.
151 of the CPC.
No, reduced section 1. Order 41 rule 27. Reduced section.
The application, write it again. This application is filed under order 41 rule 27. Read with order 26 rule 9. And section 151 of the CPC for issuing of a commission to measure and demarcate the land entitled suit number 2 of 2024. Or 2004, title suit 2 of 2004. The respondent number 1. Respondent number 1 had filed the objection.
Yes.
Respondent number 2 which? Acha, in the other one, he wants time to file affidavit in reply to your objection for commission on
Because
the...
it was received on only on 7th May.
7th May.
Yes.
7th May.
But it was filed on 10/3. Okay, we'll give him some time. So, the respondent number 1 has filed the objection to the said petition, and the counsel, Mr. A.C. Sharma, appearing for the applicant, wants some time to file affidavit in reply to the same. prayer is allowed. List the I after, list the matter after 2 weeks.
No.
It will come along with the I. And this I will be disposed of. This I will remain. 203 will.
Registry will fix it.
Okay. On a date to be fixed by the registry.
On the day you fix it. On the day you fix it.
Or you will come from Gauhati, fix a date.
25th August.
List it on 20. Yes. You take yours.
Yes, because 26th of
25th August, Monday.
August.
Because 25th is Gauhati High Court.
But the
Achha. Here it is open.
Okay.
25th. Okay.
But the affidavit that replied, the arrest will be
25th of August 24. It is further. The counsel would file the affidavit in reply before that and serve a copy upon the respondent, counsel, Mr. Longzen, respondent for respondent number 1. Before that, he will serve it. Okay. The matter to be listed after. This will be listed on this day. I 2205 will be disposed on, and this I will be live.
204.
204. Okay. I must have mixed up papers. Just see. I might have mixed up papers. Just see. Yes.
For honors, item number 27.
27. This is MSc appeal. No one appears, right? Service of notice. Service is awaited. None appears on call. It is reflected in the office note dated 25/6/2025 that service report on respondent number 1, 4 and 5 is awaited. Since the steps were taken only recently, the service upon the said respondents may be awaited further. Listed after 2 weeks.
For orders, item numbers 28 and 29.
May I please, my lady?
Yes. Yes.
My lady, I'm
This is an-
very sorry. I was stuck in a mudslide near Zubza Junction, Zubza bypass. I could not appear physically before the come of the court. My
No,
lady,
it's okay.
there is an application under Section 5 of Limitation Act for condonation
But the
of delay
service
of,
report, service on 1, 2 and 3 are not complete. You are for?
Lordship, by instruction, you appear for respondent number 1 and 2.
Not 3.
Not 3.
She appears for 1 and 2, but she is not appearing for 3. And the service
Yes,
report
yes.
is awaited.
Yes, I also have the
You are not
instruction.
audible also. There is some problem with the network. So let
Am I
the
audible
service
now?
be complete on respondent number 3.
Yes, 3 is the
We will
owner
await-
of the vehicle, my lady.
Okay, let the service be complete upon him.
Okay,
And
in the meantime, my lady, actually, tomorrow the execution case is fixed before the learned MSc Mokchung. So earlier, my lady had passed an order till returnable of the what is called service of notice. So if I may be given some protection on that, because if the execution proceedings are taken, the goodwill of the company will be at stake. So if little protection may be given to the company.
No, this IA 91 is for what?
IA 91 is for condonation of delay, my lady, for restoration of the appeal, main appeal.
So let the delay be condoned first. What order? There cannot be any other order in this. Right. So
Yes,
we will await
yes.
service of notice upon respondent number 3. And as far your case tomorrow is concerned, you tell the court that the appeal is pending. Right.
Okay, okay.
Heard, Mr. Your name, please?
Vikramjit Devnath, my lady.
Vikramjit Devnath for the applicant and Miss So-and-so, who appears for respondent number 1 and 2. You have filed. Miss So-and-so, for appearing for respondent number 1 and 2, submits that she has filed her Wakalat number only today morning. And it is further seen from the office note that service upon respondent number 3 is not complete. Since the steps have been taken recently, the service upon respondent number 3 may be awaited further. List the matter after 2 weeks. Okay? After 2 weeks on a date to be fixed by the registry.
Okay, my lady, if an order, speaking order may pass with regard to that execution case for tomorrow.
See, the condone, the delay is not condone, you are talking about execution case. You tell the court tomorrow that the cases are pending before High Court. Okay? That will suffice.
Okay, my lady. Okay.
And no more matters.